Hello and welcome everyone. I hope this message finds you fit and fine. We are in part 6 of Indian Constitution. In the previous class, we discussed governor, and today we need to talk about chief minister. As we have already covered the office of prime minister, so chief minister would be cakewalk for you. So let's start with chief minister. CM is the de facto head of state government. What does it mean? It means real power in the state government remain in the hands of CM. And governor is de jure or nominal head, symbolic you can say. As per Article 164, CM shall be appointed by governor. But do governor has discretion in this regard? No, there's a process, there's a standard which governor has to follow. And the standard is the conventions of parliamentary system of government. And what is the convention of parliamentary system of government? It means governor has to appoint leader of majority party of state legislative assembly. Okay, it means you are going to vote in MLA elections. So whichever person is going to get support of more than 50% MLAs of a state legislative assembly is going to be appointed as CM by honorable governor. What if I say that CM is going to be appointed by governor whoever is having majority support in state legislative council? Do you think that statement would be correct? No, that statement would be wrong, because majority support is needed in state legislative assembly. Same like in case of union, we talked about in parliament, majority support in Lok Sabha is needed for the position of prime minister, not of Raj Sabha, right? Now, no party has clear majority. Consider there's a case of hung assembly. So this condition is known as hung assembly. Okay. Now, who governor is going to appoint as CM now? You can take example what happened in what governor did in case of Goa. So Goa is having 40 assembly seats, out of which you need 21 MLA support to appoint someone as CM. So there, Congress got 17 seats, BJP got 13 seats in the previous elections I'm talking about. Now no single party or coalition was getting 21 mark. So now in this case, governor is going to use his or her discretion. Please remember, discretion means it would be the decision of governor only. Who he or she is going to give the chance for taking oath of CM. Now, you would be thinking, sir, if someone is not getting more than 50% MLA support, then how can this person be taking oath of CM? Yes, it is possible if governor gives you chance. But there's a condition here. Condition is that within the time frame which is given by governor to that concerned person, means CM, that person has to prove majority support in floor test in the state legislative assembly. It means you have to prove within this time that yes, I have more than 50% MLA support. It means you need to get support of other parties as well, right? I hope it is clear to you now. The governor usually appoints the leader of the largest party or coalition. In this case, governor can give chance. Plus, please remember, UPSC can play with you by saying this is mentioned in constitution. Okay, in case of hung assembly, what governor is going to do is not mentioned in Indian constitution. That is why it is part of governor's discretion. Okay, I hope you remember when I was discussing center-state relations, then I mentioned about Sarkaria Commission and Punchi Commission report. And there I also discussed that this governor's discretion is also a point of conflict between center and state, right? A person who is not a member of state legislature, can that person be appointed as CM as well? Yes. For example, you have not participated in any election, right? But you can be appointed as CM as well. This is possible. And how is it possible? If more than 50% MLAs of state legislative assembly supports your name, give your name to the governor, then you can be appointed as CM. But you need to be part of any of the house. If there are two houses in state legislature, say legislative assembly, legislative council, so you need to be part of state legislature within 6 months period. Otherwise, your CM position will be taken away. Okay, so it means not a member of state legislature, still you can be CM. UPSC asked this question. This was a statement which was used. But within 6 months, you need to be part of any of the house. If there's one house, then you need to be part of this house. Okay. Now, can a member of state legislative council be appointed as CM? Or it is mandatory that a member of state legislative assembly only can be a CM? Now, even if we have not discussed, now think the convention which we discussed in case of Prime Minister. So I told you that Manmohan Singh ji was Rajya Sabha member, still he was Prime Minister, right? Same is the case of CM. For example, UP CM, Mr. Yogi Adityanath, so he was part of Legislative Council and he took the oath of CM, right? So it means LC or LA. You can be member of any of them, right? Within 6 months period. According to Constitution, Chief Minister may be a member of any of the two houses. This is what I have just explained you with example. Now, oath. Governor is responsible for giving oath to the CM. When it comes to term, if a statement is used and the statement is saying, Chief Minister of a state is having 5-year term, tell me that statement would be correct or not. Some of you would say, sir, yes, the statement seems correct. Because we have seen many chief ministers have completed 5 years term and after 5 years there's an election. But my friend, that statement would be incorrect. You know why? Because CM position has no fixed term. There's no fixed term with the position of CM. CM is there just till the time that person is having majority support of State Legislative Assembly. That's it. Okay, so no fixed tenure. Can governor remove CM at any point of time? Because it is said that CM is there for the pleasure of governor because governor has appointed CM. No, governor cannot remove CM until and unless this CM actually loses majority support in State Legislative Assembly. Okay, this does not mean that governor can dismiss him at any time. This is what I have explained to you. He cannot be dismissed by governor as long as majority support of State Legislative Assembly is with the CM. Okay. If he loses confidence of the House, then CM must resign or governor will actually dismiss him. Okay. So majority support in State Legislative Assembly is mandatory. Now, when it comes to power and functions of CM, number one, CM is like a bridge between governor and Council of Minister. Means governor is expected to ask CM if you want any report on any department. You should not directly approach the department officials. This kind of controversy we have seen in case of West Bengal, in case of Tamil Nadu governor, right? So governor appoints only those Council of Minister members. Those lists are being given to governor by CM. It simply means governor has appointed CM, whoever got majority support in State Legislative Assembly. Now CM will give a list to Honorable Governor. Sir, these 20 names I have fixed and please give them, appoint them as ministers. So governor is appointing these ministers in State Legislative State government, but the list is given by CM. So that is why we say that this Council of Minister is at the level of state is CM's Council of Minister. Same convention applies like we discussed in case of Prime Minister. The point Prime Minister resigns, Council of Minister also resigns. We discussed. This is like a ship. They actually swim and sink together. Same convention applies in case of state government as well. He allocates and reshuffles the portfolio among ministers. Consider that you are a minister in UP government and you are given a charge of PWD department. But we have found that you have not done satisfactory work. And CM thinks you have not done satisfactory work because you have to satisfy the vision of that CM, right? CM is the leader. Now, if you have not done that work, it may be possible that CM will say, now I'm taking your PWD ministry and now I'm giving you another ministry. Okay, say Environment Ministry, Technical Education Ministry, Women and Child Welfare Ministry. Okay, and if you don't perform well there, then CM can remove you from there as well. But how CM is going to remove? CM is going to ask you to resign peacefully. If you are not resigning, then CM will give your name to the governor. Sir, please dismiss him or her. Then you will be dismissed. Okay. He can ask minister to resign or advise. I told you. And if you don't resign, then governor is going to dismiss him on the advice of CM. And if the advice of CM regarding dismissal of a minister is mandatory on governor, yes or no? Answer is yes. Because Council of Minister of State is actually Council of Minister of CM. That is why governor has to accept this recommendation of CM. Presides over the meetings of Council of Minister, as I told you, leader, guides, direct, control and coordinate the activities of ministers. What does it mean? It means CM is going to communicate to you that these are the goals which we want to achieve, and that is why you are given this ministry. Now, in relation to the governor, as I told you, governor and between governor and council of ministers, CM is like the bridge. Okay. Now, it is the duty of chief minister to actually communicate about the administrative decisions which you are taking to the governor. Now, some of you would be thinking, sir, why CM has to communicate these decisions regarding the administration to the governor? Because governor is not having any real power. But my friends, in the previous video, I discussed that governor is actually the head of the state executive, right? Executive actions are taken in the name of governor. That is why it becomes a necessity. Okay. So furnish such information as governor asks regarding state legislature or state administration. So it is duty of CM. Okay, I'm using the word CM again and again because UPSC will frame a statement, and then in that statement UPSC will use governor will actually ask a concerned minister of a state government to furnish these details, and then minister is bound to furnish this detail to the governor. That statement is true or false? Actually, convention says otherwise. Convention says CM is the link. Okay. If governor is so required to submit for consideration, consider a case that you are a minister and you have some idea, and that idea has been discussed a lot, but your idea has not been taken up for discussion among your council of ministers. So in this case, governor can communicate this to CM. Sir, I have heard, Mr. CM, I have heard that this was an interesting idea of one of your ministers. Why you have not taken up this in your council of ministers meeting? You should take up. He advises the governor, and CM advises the governor with regard to important appointments. For example, in the previous video, I asked one question: who appoints SPSC chairperson? The question was who removes, because there's a twist there. So within the solution, I told you SPSC chairperson members are appointed by governor, but on whose advice? CM's advice. Okay, and CM's advice is mandatory. Same with state election commissioner. Same with advocate general. Advocate general, the senior most legal officer of the state government. Like we have attorney general in union at central level. Now, in relation to state legislature, he advises the governor with regard to summoning and proroguing. Now, in the legislative power of governor, I told you that house of a state legislature can be summoned and prorogued only by governor. Summon means to call the house, and prorogue means to ending the proceedings of the house, right? Start and end. Who is going to do that? Governor. But on whose advice? CM's advice, along with council of minister. Okay, and this advice is mandatory. He can recommend the dissolution. Consider, now CM is thinking that I want election, right? And even if there are 6 months left before the completion of 5-year term of state legislative assembly, but I want elections. So now the CM can recommend to the governor, so please dissolve this legislative assembly and we want election. So in this case, governor can actually do that. He announces the government policies on the floor. Who announces? The CM announces the government policies. Other powers, chairman of the state planning board. Now please remember, UPSC is asking these kind of factual questions, right? Regarding CM, 1 or 2 questions may be conceptual and 1 question would be factual. Like CM is vice chairman of zonal council by rotation for 1-year period. Maybe member of interstate council, right? So this question was already asked, right? And other statement can be interstate council is headed by CM on the rotation basis. Now tell me the statement would be true or false. It would be false, but the UPSC will try to confuse you between zonal council and interstate council. But if you know that these are the traps, now you are not going to fall into traps, right? Chief spokesperson of the government, because prime responsibility of government lies on the shoulder of CM, and that is why CM is regarded as crisis manager of the state government. Relationship with the governor. Now, what we have discussed until now, the provision related to CM, now we are going article wise. Okay, Article 163, it says that there shall be a council of minister headed by chief minister to aid and advise governor. Now, our constitution has not elaborated on this fact. What does this aid and advice means? Is it mandatory or is it just advice as we know in dictionary? But the convention has developed that in parliamentary system, in democracy, real power should be with elected government. And that is why this aid and advice should be considered mandatory. But there's a twist there, which we don't find in the case of president. In Articles 163 subclause 1 it says it like this, but in subclause 2 it says that the discretion, the word discretion means where governor is going to act on his own, not with the advice of CM. Who is going to decide in what cases you need to act as per discretion? So actually our subclause 2 says that this is going to be decided by governor only. And this is the fact on which we say that governor's discretionary power seems to be more than president. And this specific statement can be asked in your exam. Please remember, as per Article 163 subclause 2, governor is the one who can decide the areas where governor is going to take discretionary action, not on the advice of Council of Ministers. But such provision is not present in case of President of India. I hope it will be clear to you now. Article 164, CM shall be appointed by the governor, you know it, and then CM will give a list to the governor, sir, please appoint these people as ministers. Then governor will appoint them. Minister shall hold office during the pleasure of governor. Why we are saying pleasure of the governor? Because governor is the one who is appointing them, and minister don't have any fixed tenure. The moment CM says, sir, I've asked this minister to resign, but he's not resigning, just dismiss him. So he will be dismissed. Ordinarily, if CM says you have to resign, then you resign, because you know how your political career is going to end then. The Council of Ministers shall be collectively responsible to the Legislative Assembly. Now, please remember, in case of COM at the level of union, I told you the meaning of collective responsibility. It means you are minister, you have government only till the point you have majority support in Legislative Assembly, right? The moment you lose that, then you will actually resign from the position, okay? Article 167, as I told you, communicate. CM is responsible to communicate about the administrative decisions, furnish the details as asked by governor with respect to legislative or executive part. Governor requires submit for consideration of the, so this is what I have discussed this. I told you now, if concerned minister is having some important decisions to take, but that particular proposal has not been taken up at the level of Council of Ministers, in this case, governor may convey to the CM that please take up this matter. So this matter can be taken up. Now let's attempt some questions. Assertion: Chief Minister of the state can disqualify a sitting MLA after obtaining the advice of State Election Commission. This is assertion. Do you think that statement is correct? This statement is incorrect. If someone, even after going through this Kanthas series of Lakshmikant, is saying this statement seems correct, then that is a sinful act. Okay? That statement is incorrect. Chief Minister is the de facto head of the state. This is correct. Now, look at the options. A is incorrect, R is correct. It means 3. 3 is the answer. Right? Now, second question. Which of the following is not correct about the Chief Minister? Not correct about the Chief Minister. Council of Ministers shall be collectively responsible to the Legislative Assembly of the state. Article 154 states that governor will appoint the Chief Minister. Now, if you say this, see this. So this part of the statement is correct. Okay. Although UPSC can ask this question like Chief Minister and COM. Okay. Now, but even if you don't remember 154, but since you are going to go through this part so many times, you will remember that in 164 I told you Chief Minister shall be appointed by governor. It was 164. And what question is saying? It is saying 154. So it means not correct is second option. Right? Now, what is the minimum age for the appointment of Chief Minister of a state? Although our constitution has not specifically mentioned that this is the minimum age criteria for CM. But since it says that within 6 months, even if you are not a part of state legislature, within 6 months, you have to be you have to be member of any state legislature. Means legislative council or legislative assembly. And what is the minimum criteria? What is the minimum age which you require to be part of legislative assembly? Means MLA. That is 25 years. So that is why answer is 25 years. Okay. Which of the following is not matched correctly? Now, so in these kind of questions, Sometimes students think, oh, I don't remember all the articles. It means this question is going to go in vain. No, that's not correct. You should attempt. In Article 163, I just explained you that governor, there will be a Council of Minister headed by CM, aid and advice governor, right? And I told you 163 subclause 1, 163 subclause 2 talking about discretion, right? But look what 163 they are saying, swearing in of CM. It means this is not correct. So it means it may be possible you have gone through one or two articles so many times that one or two article may be matched incorrectly. So that is why you should attempt such questions. And today we need to talk about State Council of Minister. But before I start, let me remind you one thing. I told you when you start states part, that is part 6 of Indian Constitution, with each topic, have a comparative understanding, have a reflection, what we discussed in part 5. For example, when we covered governor, we were comparing with president in part 5. Why? One is, many processes, provisions are same. So it would be cakewalk for you to understand this, to retain this. Second is, sometimes UPSC play on differences part. For example, difference between some parts of president and governor, right? So since we have discussed Union Council of Minister, processes and provisions are same. So here you are going to revise as well. Okay. So as the Constitution of India provides a parliamentary system at the level of union as well as state. Yes, at the level of state as well. Although we don't use the word parliament for state legislature, but the system is parliamentary. Why? Because we have a council of minister at the level of state. We have this government being formulated on the basis of majority a party or coalition gets in state legislative assembly, right? We have this council of minister collectively responsible to legislative assembly. It means features of parliamentary system are reflected in state government or state legislature as well, right? So in the state's union pattern, that is what I've explained to you, the council of minister in the state is constituted and function the same way as I told you as the council of minister at the level of center, same way. What does it mean? First is constitution, means how they're formed on the basis of absolute majority a party or coalition gets in state legislative assembly, not council, right? Please remember, assembly, MLAs, not MLCs, right? Then I also told you, when it comes to chief minister, in chief minister chapter we discussed, chief minister can be an MLA or MLC. And I told you it is same in case of PM. Like Manmohan Singh ji was member of Rajya Sabha. Similarly, assembly and council consider upper house at the level of state legislature, right? But when it comes to forming government, you need majority in assembly. For example, you need majority in Lok Sabha at the level of union, right? Absolute majority. Now what constitutional provisions say? I hope you remember Article 163. We discussed it before as well, because these topics, governor, CM and council of minister, they are interlinked, right? There shall be a council of minister with chief minister as the head to aid and advise governor. I hope you remember. I also told you about Article 163 subclause 1 and subclause 2, right? And what is the difference? Can you recall? If any question arises, and this is subclause 2, arises whether a matter falls within the governor's discretion or not, decision of the governor shall be final. This is subclause 2 of Article 163. And I told you, this kind of power is not available to Honorable President. Okay, so that is why please remember, because UPSC play on these things. These are the traps. The advice tendered by minister to the governor not be inquired into any court. Advice given to governor, you cannot inquire that. This is a kind of privilege which is given to minister. Okay. Now some of you might be thinking, so this is wrong. What if these ministers give wrong advice to governor? Advice which is unconstitutional. What is going to happen then? For once, governor can say, Council of Minister, please reconsider your advice. And if they fix on their advice, no, I'm not going to reconsider, then governor has to accept. But you need not to worry, because if there's a legislative action or say executive action which is unconstitutional, then we have our higher judiciary to interpret the constitution, right? And if such thing happen, then they are going to declare that particular law as null and void. But they need not to go into this advice. They can just struck down the output. Okay, I hope you got the logic now. Article 164, other provisions related to ministers. This also we discussed. The states of Chhattisgarh, Jharkhand, Madhya Pradesh, Odisha, there shall be a minister in charge for tribal. I told you how ministers are appointed. Actually, when one person got more than 50% MLAs supporting him or her name as CM, then governor says, okay, now you are going to be CM of that state. Now that person gives a list to who? Governor. Sir, please appoint these people as ministers. Now governor is going to appoint those people as ministers, right? Now who is going to get what ministry is also a decision of CM, because it's CM's council of minister, right? What kind of ministries CM needs, that is also a sole decision of CM, right? But in case of these states, there's a mandatory clause that you need a dedicated minister in charge for tribal affairs. And what's the logic? Logic is presence of considerable number of tribal population here, right? Welfare, who in addition in charge of the welfare of scheduled castes and backward classes. Now, a state of Bihar was excluded from this list. Okay, so UPSC sometimes play on facts now. So this can be a fact on which UPSC can play. Now the total number of ministers, 15% of the strength of the Legislative Assembly. Please remember, 15% strength of what? Legislative Assembly. What does it mean? Consider there are 100 seats in Legislative Assembly, State Legislative Assembly, means 100 MLAs, right? Now a party get 60 seats. Now that party is going to form the government. Now CM has, this issue, right? We have more than 60 MLAs, and I have to make some of them as ministers. Like this was in discussion recently in Punjab, right? So many MLAs were saying, no, I'm going to be minister, I'm going to be minister, otherwise I'm going to get angry or I may actually join another party. So now we need a rule for that. Earlier, actually, this provision was not mentioned in Constitution. And that is why, under the pressure of these MLAs, sometimes these CMs actually used to appoint so many people as ministers. And then problem is, you have to give each of them as a particular bungalow and the car, the staff, etc., things, right? Allowances, privileges, etc. Now, apart from that, if you have formed so many ministries, don't you think it will be a troublesome job to get a policy action done? Because it may be possible for a particular work, you need approval of 3-4 departments. If 3-4 departments are attached to one minister, then that one minister can actually enact that policy in a faster manner. But if there are multiple ministers heading these small departments, then it would be difficult for actually enacting that policy, right? So burden exchequer as well as administrative inconvenience, and that is why 15% was made the standard. It means out of 100, that is the total strength, you can only make 15 ministers along with CM. Okay. The number of ministers including CM in states shall not be less than 12. So maximum is 15% and minimum is 12 for states. Okay. 91st Amendment Act was that. Now a member either of as I told you, you can be a MLA or MLC to become a minister. Right? And even if you are not a member of Legislative Assembly or Legislative Council and you want to become a minister, and CM thinks, yeah, you are going to be a good asset in his Council of Minister or her Council of Minister, then such action can be taken. But same rule applies that within 6 months, you have to become part of, or you can say member of, one of these houses. If there are 2 houses in that state legislature. Okay. Another is, consider you are disqualified on the grounds of defection. As I told you, 10th schedule of Indian Constitution, anti-defection law, right? So if you are disqualified on the ground of defection, now you are going to be removed or disqualified from the appointment of minister as well. Okay, you cannot say, oh sir, for the appointment there's a rule that I can be there for 6 months without being a member, so allow me to be a minister although I'm getting disqualified from. No, the moment you get disqualified from the house, you are going to be removed from the post of minister. Okay, 91st Amendment Act. Now, the Council of Ministers shall be collectively responsible to Legislative Assembly. What does it mean? If no confidence motion is passed here, then the whole Council of Ministry has to resign. Governor shall administer oath. So, who gives oath? Governor gives oath to these ministers. Minister who is not a member of the state legislature, as I told you, 6 months, they can be there. Once the conduct of business of the government. So, I hope you remember in the governor chapter, I told you, the executive actions of the state government are taken in the name of governor, right? Like president is the executive head at the level of union. Similarly, we have governor as the executive head at the level of state. But nominal power, real power is in the hands of CM. Executive action of the state shall be taken in the name of governor. Now, validity of an order. Consider you're a minister and you have signed a file for a particular, say, policy action. So, is it mandatory that it need to be countersigned every time by the governor? No, that's not necessary. Okay. So, what does it mean? You can actually have a noting on the file in the name of Honorable Governor of Uttar Pradesh or Madhya Pradesh, whichever state we are talking about. These policy actions have been decided to be taken, and I being a minister in charge of this particular ministry, I am giving this authority that this policy need to be implemented and signed. So, it will be considered, yes, governor has agreed. But in which category giving file to the governor is mandatory, in which category you need not to give file to the governor. So, regarding this, rules and procedures can be decided. Governor shall make rules of the more convenient transaction of the allocation business. Convenient transaction, why? Because every file should not circulate towards governor. It will actually create unnecessary delay in policy actions, right? So, such rule can be made by governor, but obviously on the advice of Council of Ministers. 167 duties of Chief Minister. We discussed it. To communicate about administrative actions, to furnish details of legislative policies which they are planning, their government are planning, right? As I told you, CM is like a bridge between State Council of Ministers as well as governor, right? Rights of ministers as respect to the house. Consider there are two houses in that state. Legislative Council, Legislative Assembly. And you are member of Legislative Assembly, you are MLA. So, you have this right to be present in LC or LA both. Why? Because it may be possible some member of LC, Legislative Council, want to ask some question from you. Then you have to present there, give the answer if such is the demand of the house, right? But you cannot vote in the other house. Vote can be given only in that house in which you are member. Right? Same clauses with Union Council of Ministers, we discussed this. Nature of advice by the ministers. As I told you, advice tendered by the Council of Ministers, they are mandatory for the governor, right? Reconsideration can be done for once, right? Otherwise, they are mandatory. Although there are some discretionary areas as well. So, Supreme Court ruled that Council of Ministers must always exist to advise. Such is the importance of Council of Ministers. Even after dissolution of State Legislative Assembly. Consider State Legislative Assembly has been dissolved, right? So, it means now this particular Council of Ministers doesn't stand any chance to actually function formally. But this Council of Ministers can work as a caretaker government. So, this is going to be caretaker government. The word is may. Please remember UPSC can play here. UPSC can use a statement and say the existing ministry, means they can attach this particular statement with that, and they say it is mandatory that at any time, every time, there will be a state council of minister. They can play with you along these lines. But please remember the word is may, means it is possible. It can be done. Appointment of ministers. So, Chief Minister is appointed by Governor, then Chief Minister gives list to the Governor, and then Governor appoints other ministers. Responsibility of the ministers, as I told you, they swim and sink together. If no confidence motion is passed, it means this government stands no chance to continue as government, then ministers have to resign. Same as case of Parliament, yeah, Lok Sabha. Council of Ministers can advise the Governor to dissolve Legislative Assembly before time as well, right? There can be re-elections. Does not represent the views of the electorate faithfully and call for fresh elections. So fresh election they can call for. It is duty of every minister to stand by the cabinet. What does it mean? Consider, you have some independent views and you have read Article 19, subclause 1, subclause A, and you are saying, I am having my freedom of speech and expression. Now you are a minister, but the cabinet means the key ministers, cabinet minister, the key ministers, they decided, no, we have this stand on this policy, but you are having different stand. Now, can you actually continue as a minister in this case? It is duty of every minister to stand by the cabinet and support them both within and outside the state legislature. And if you are saying, no, I'm going to use my freedom of speech and expression, I'm not agreeing with what CM is saying, I'm not agreeing with what other cabinet ministers are saying, and I'm going to raise voice against my own government. If you do so, you may be asked to resign, buddy. Means if any minister disagrees with a cabinet decision and is not prepared to defend, he must resign. Okay? I mean, some of you would say, sir, it is actually, freedom of speech and expression are being compromised. You may say that. But please remember, when you are a minister in CM's Council of Ministers. CM is the leader. You have to uphold his or her vision, his objective. If you're not fulfilling that, you will be asked to resign. Individual responsibility. Contain the principle of individual responsibility. Governor can remove a minister at a time, but on what basis? If CM advises so, right? Or if that person is disqualified, right? Then obviously that person is going to go. Or it may be possible that now this particular Council of Ministers is not having majority in the Legislative Assembly. Enjoy the confidence on the advice of Chief Minister. On that advice of Chief Minister, Governor can actually remove. Okay? In case of difference of opinion and dissatisfaction with the performance of a minister, in this case also CM may ask you to resign, right? Please remember, UPSC can play on these part. UPSC may try to confuse you between governor's power to remove minister, its cases, and governor's power to remove a member of state legislature and its cases. Please note it down and identify the differences. Okay? And let me know in comments that so that I can be sure, yeah, you are actually giving attention to these intricacies, these details. Right? General understanding many students are going to have. But you have to become, that kind of master that any question which is thrown upon you, you're not going to mark it wrong. Such should be the clarity because everything is logical. No legal responsibility. As at this level of center, no provision in the Constitution for the legal responsibility of the minister in the state. It is not required that an order of governor for a public may be countersigned by the governor. Court are barred from inquiring into the nature of advice. As I told you, that court are not going to barge into the advice, why you have given this advice, right? Whatever advice they have given, if you're not agreeing with the decision, just declare this null and void if it is unconstitutional. As simple as that. But you cannot take legal action on the minister that why you have given this advice, right? This protection has been given. Composition of Council of Ministers. Constitution has not specified any size, right? Does not specify any size of the State Council of Ministers. Please remember, it can be a question. That it is determined by CM. Like at the center in the states to council. Why I'm saying doesn't specify any size? Some of you might be thinking, sir, you just said about 91st Amendment, you said about 15% maximum. So don't you think that 15% strength of the total Legislative Assembly, we need at least these many ministers? No. I've said maximum ministers can be 15% of the total strength of Legislative Assembly. I have not said you need 15%. That's a decision of CM. CM may say, no, I'm going to have just 10 ministers. I'm going to have, so minimum is 12. So I'm going to have 13 ministers. I'm going to have 15 ministers. That is total discretion of CM. Okay? But specific strength, what is going to be specific strength? That is not clearly mentioned in our Constitution. There are three categories of ministers, same at the level of union. You have cabinet ministers, you have minister of state, then you have deputy ministers, right? So these are the details. Cabinet ministers, these are the main ministers, means like the part of inner circle of CM, right? Having important portfolios, most important portfolios, home, education, finance, agriculture, and so forth. They are members of the cabinet, attend its meetings, and play an important role in deciding policies. Actually, from among these Council of Ministers, real power is in the hands of cabinet ministers. Their responsibilities extend for the entire gamut of state government. Prime responsibilities with them. Minister of State, they can be given independent charge or they can be just Minister of State. Okay. When I say independent charge, it means they will be having sole responsibility of the respective ministry, respective departments, right? Then we have deputy ministers. Deputy ministers are attached to other ministers. They're not given independent charge. Attached to the cabinet ministers. Now cabinet. What is cabinet? As I told you, in case of union, this is a smaller body. It's like the nucleus of the Council of Ministers, main body, highest decision-making body, chief policy formulation, supreme executive authority, chief coordinator of state government, advisory body to the government. Real power actually lies with cabinet, you can say, a group of cabinet ministers. And cabinet committees have standing committee as well as ad hoc committee. A standing committee are permanent, means at any point of time you need policy decisions on these areas. For example, cabinet committee we discussed in case of union, right? Ad hoc committee, they are formed time to time. When they are given their advice, then they can be. The Council of Ministers in the state shall be collectively responsible to the governor. Do you think that statement is true? Collectively responsible to governor or collectively responsible to state legislative assembly? Tell me, because you have to identify the correct one. The state minister shall hold the office during the pleasure of the governor of state. Who appoints these ministers? Governor appoints. Who removes? Governor removes. Same is the case of President and Union Council of Ministers, right? That is correct. The number of ministers, including the chief minister in a state, shall not be less than 12. I've just told you. So it means first statement is wrong, because here it should have been a state legislative assembly. So that is why 2 and 3 are correct, means B is the answer, right? Consider the following statement. You have to identify the correct. Legislative council of the state in India can be larger in size than the half of the legislative assembly of the particular state. So our next topic is state legislature. Okay. In that we are going to discuss the statement, but as of now you should know that strength of legislative council cannot be more than 1/3 of the total strength of legislative assembly. That's a rule. Governor of state nominates the chairman of state legislative council of that particular state. When it comes to state legislative council, the chairman is the elected position. Means from among the members of state legislative council, one member is appointed or elected as chairman. So in this case, both statements are incorrect. It means answer should be neither 1 and 2. The size of state legislative council cannot be more than 1/3 of the members of the state legislative assembly. That's a rule under Article 171. We are going to discuss it in next chapter as well. Chairman of legislative council elected by the members. Okay, then this is not appointed by the governor. Okay, nominated by governor, right? It is an elected position. In which of the following matters the power and status of council are broadly equal to that of assembly? So we are talking about state legislative council equal to state legislative assembly. So in which area they have equal say? Approval of ordinance issued by the governor, they have equal say. With respect to ratification of the Constituent Assembly, no legislative assembly has say. Selection of ministers including chief minister. Tell me, don't you think person can be a minister or chief minister even if that person is member of state legislative council, like Yogi Adityanath was member of state legislative council? So this is correct. With respect to passing of no confidence, no, obviously no confidence motion is actually a tool or procedure or device of legislative assembly, not of legislative council. That is incorrect. So 1 and 3 means B is the answer. And today we are going to talk about state legislature, part 6, Article 168 to Article 212. It is also going to be a cakewalk for you if you have a comparative understanding. Means as we go through state legislature, just reflect what we discussed in case of union legislature, parliament. At the level of center, we have two houses, bicameral legislature. We have Rajya Sabha and Lok Sabha. Similarly, at the level of state, we also have in some states 2 houses, Vidhan Parishad, which we call Legislative Council, Vidhan Sabha, which we call Legislative Assembly. Please remember, not in every state we have bicameral legislature. Okay? Which one of the following state does not have a bicameral legislature? West Bengal. Now, when this question is going to be asked by UPSC is not expecting you to cram everything. It is just that it was in news. Mamata Banerjee, CM of West Bengal, she was demanding from the center that yes, West Bengal deserve a second house. So what point you got now? One is West Bengal is not having legislative council. Another is power is with parliament, right? Now, so these are the states where we have Vidhan Parishad as well, means second house. Bihar, Maharashtra, Andhra Pradesh, Karnataka, Telangana, Uttar Pradesh. Now some facts related to organization of state legislature. Legislative Council was abolished by J&K, Reorganization Act 2019. Tamil Nadu Legislative Council Act is there but has not come into force. If UPSC is making one statement, there is no uniformity in the organization of state legislature, what would you say? You will say true or false? You will say true. Okay? Don't think that's a trap. Okay, that's correct notion, right? Because we don't have a bicameral legislature in every state, right? The 7th Amendment Act 1956 provided for Legislative Council in Madhya Pradesh. It provided, but what happened? However, a notification of this effect made by the President, so far no such notification has been made, and that is why Madhya Pradesh continues to have one house. Legislative Council Vidhan Parishad is the upper house. As you know, in case of Rajya Sabha, we have upper house Rajya Sabha, and Rajya Sabha is also regarded as second house. Similarly, Vidhan Parishad means Legislative Council is an upper house, but second house, second chamber. Why? Because in some respects, the bills are first introduced only in Legislative Assembly. For example, Money Bill. Legislative Assembly, Vidhan Sabha is the lower house, first chamber or popular house. Why popular house? Because members of Legislative Assembly are directly elected by people, right? But when it comes to members in Legislative Council, they are indirectly elected or nominated. We have 22 states. This is the structure. You are clear about this. Now composition. Attempt this question. What can be the maximum number of members in Legislative Assembly of a state? Answer is 500. So it means maximum strength can be 500, minimum strength can be 60, although there can be exception like Goa, right? Territorial constituencies means on what basis it is decided that yes, this MLA is going to represent this area, other MLA is going to represent that area. So the purpose is that each and every constituency of a state should represent a proportionate amount of population, right? For example, consider I'm an MLA and I'm having a constituency where 2 crore people are there. And there is a other MLA who is actually representing, same state, representing a constituency where there's 50 lakh people. Don't you think it is actually, you can say, injustice with the people who are part of my constituency? Because for 2 crore people, one representative. And there, for 50 lakh people, one representative, right? So to reduce this kind of disparity, this is the process which is used. Demarcation of constituency is done on the manner ratio between the population in each constituency and the number of seats in the state remains same. Okay. Now readjustment after each census. Now, I also made a separate video on delimitation commission on the main StudyIQ channel. In the Shashank series, you'll find that. Okay. There was a specific video, but let's discuss this here also. After each census, a readjustment to be made in total number of seats in the assembly of the state, each state, division of each state into territorial constituencies. But this is what provision says, but it doesn't actually happen, right? Means you know that after 10 years we have census, but after 10 years, it is not necessary that number of seats and the territorial constituencies are being changed. Right? So why they're not being changed? Because Parliament has enacted Delimitation Commission Act 1952. So this Delimitation Commission is responsible to decide the boundary, okay, of the constituency. So these acts were made for this purpose, but 42nd Constitutional Amendment Act 1976 had frozen the total number of seats assembly of each state and the division of the state. So the point is, there was disparity in population, means in state-wise as well. For example, in 1970s, when government started this population control program, family planning program, to some states, for example, southern states, they have done good job, right? For example, Karnataka, Tamil Nadu, Kerala, Andhra, they have done good job. So that is why the population growth rate in these states after this 1970s was considerably managed in comparison to the northern states like Uttar Pradesh and Bihar. Now think, if you, after 10 years, you are actually bringing a census and you are also deciding on the basis of population that this particular state is going to have how many seats in Lok Sabha as well. So don't you think this would be injustice with the southern states? Because northern states have not done their homework well, and their population has increased leaps and bounds. And since they have more population, then by the logic of delimitation commission, now these highly populated states are going to have more seats in Lok Sabha and Rajya Sabha than these southern states. So don't you think this is wrong? These states have done good job, and that is why their representation is being reduced, right? To reduce such disparity, that is why these seats were actually later, this readjustment was banned for some time. As of now, this readjustment is going to happen after 2026. Now, some of you would think, sir, why 2026? Because idea was that in between this time, this growth rate disparity between states can be normalized, minimized. But there are some opinions against that as well. But we should know that as per 84th Amendment Act, it has been, you can say frozen till 2026. Now, later 87th Amendment Act 2003 provided for the delimitation of constituencies on the basis of 2001 census and not 1991 census. However, now what is going to happen? Just read this line. This can be done without altering the total number of seats in the assembly of each state. We are not going to alter the total number of seats. Now, some of you would be thinking, sir, we got the point that the number of seats from each state in Lok Sabha need not to be reduced. Otherwise, this would be like less representation to that state in parliament, right? But why there's such hue and cry on reducing or increasing the number of seats in state? So this can happen. So the point is, if a particular state, say northern state, got more population and their number of seats are increased, so don't you think their weight in election of president will also increase? Because in election of president, who votes? Elected MLAs vote, right? So to reduce this disparity, this logic was said that you are not going to alter the total number of seats in the assembly of each state. Okay? Reservation of seats for SCs and STs. Now, if I ask, a statement is minimum 15% seats. As per constitution, minimum 15% seats need to be reserved for SCs and STs in each state, in each state legislature. Do you think that statement would be correct? I say 7.5% for STs and 15% for SCs. Now tell me, is it correct? Answer is no. Why? Because reservation is there, but as per population. It may be possible now that there's some state where there's no population of tribals. What is going to happen then? What is the use of having 7% seats reserved for STs there? Right? That is what the logic was on the basis of population. Clear? So you should not mark wrong answer in exam now. Our reservation was initially for 10 years. All of are aware of this. Later it was extended and then it was kept on extending. Now, composition of council. Unlike the members of Legislative Assembly, the members of Legislative Council are indirectly elected. I told you, indirectly elected plus nominated. Okay. Now, what is the maximum strength of a Legislative Council? So, Constitution is not said ki, or any law is not saying ki this is going to be the maximum strength. It simply says maximum strength cannot be more than 1/3 of the total seats of Legislative Assembly. Means at 1/3 of the total strength of the assembly, and minimum strength is 40. What does it mean? Consider maximum total strength of a legislative assembly is 90. Okay. Now tell me the total strength of legislative council of that state can be what? 1/3 of 90 is 30, right? So it means the total strength of legislative council of that state can be 30, okay? It means that size of the council depends on the size of the assembly. This can be a direct statement which can be asked, because I told you the size of legislative council depends on the size of legislative assembly. 1/3 logic maximum. Now manner of election. In legislative council we are talking about, because in legislative assembly there is direct election from the people. Legislative council, 1/3 of the members are elected by members of local bodies, panchayats, municipalities, municipal corporation. 1/12 are elected by graduates. Now some of you might be thinking, sir, we are graduate and we have never voted in this legislative council election. Because for that you need to be added in electoral roll of that state for this legislative council elections. Then 1/12 are elected by teachers of 3 years standing in the state, not lower in standard of secondary level. Please go to this kind of detail as well. Then 1/3 are elected by members of the legislative assembly, and the remaining are nominated. So how you can remember it easily? 1/3 is more than 1/12, right? So more weight in this indirect election of legislative council member is given to political representatives. These are political representatives, members of local bodies, and these MLAs, members of legislative assemblies, these are also political. So 1/3 seats are decided, or you can say elected by political. Okay. Now comes the role of teacher and student, means graduate. So teacher and student have 1/12, right? And remaining 1/6, they are nominated by governor, right? It is quite easy. Now, on what basis governor can actually nominate? Obviously on the advice of council of minister of the state, but their bases are literature, science, art, cooperative movement, social service. It means 5 areas are there, okay? So it means 5/6 of the total members of the legislative council are indirectly elected, means 1/3, 1/3, 1/12, 1/12. It means 5/6, and 1/6 are nominated by governor, okay? Now duration of 2 houses. Normal term is 5 years. I'm saying normal term. It may be possible before that, right? House can be dissolved. However, governor is authorized to dissolve the house before that on the advice of council of minister, right? The term of assembly can be extended during the period of national emergency by law of parliament 1 year at a time for any length of time. This we discussed in emergency chapter as well, right? The extension cannot continue beyond a period of 6 months after emergency ceased to operate. In case of national emergency we are talking about, okay? Now duration of the council. Now equate this with Rajya Sabha. Legislative council is a permanent body. 1/3 of its members retire on the expiration of every 2nd year. Same in case of Rajya Sabha we discussed, right? So the vacant seats are filled by fresh elections, nomination by governor at the beginning of every 3rd year. This happens. So it means total duration would be 6 years for that particular member of legislative council. If I say the tenure of legislative council of state legislature is 6 years, do you think that statement would be true? No, because there is no tenure to the permanent house. Tenure word means this particular position or this particular house will cease to actually exist after this time. There is a need of separate election, right? But this is not the case of legislative council. It is same in case of Rajya Sabha, right? The retiring members are also eligible for re-election, re-nomination any number of times. There is no bar on that. Now attempt this question. You know, in Delhi, Delhi is a UT, but it is a special case. In Delhi, you have legislative assembly, you have CM Arvind Kejriwal, right? In which year this was actually turned into a legislative assembly of 70 members? So answer is 1992. Now members of state legislature, membership, qualification should be a citizen of India, subscribe oath by the election commission. For becoming a member of legislative council, minimum age is 30. Same in case of Rajya Sabha. As in case of Lok Sabha, minimum age is 25. Same in case of legislative assembly, 25. The parliament has laid down qualifications of Representation of People Act. Representation of People Act provisions are same as in case of parliament. A person to be elected legislative council must be an elector. Now, other provisions are same. For example, disqualification provisions. Okay, but these provisions are specific. Question may be asked. Okay. And UPSC might try to confuse you by saying for fighting an election of a Lok Sabha MP, that person should be a registered elector in that particular constituency. Now tell me the statement would be true or false in comments. Now come back to this. If you want to become member of Legislative Council, then you should be an elector for any assembly of constituency of that state. If you want to become member of Legislative Council, you need to be an elector in that state. And to be qualified for governor's nomination, he must be a resident of concerned state. Right? Concerned. A person to be elected to the Legislative Assembly must be an elector for an assembly constituency in the concerned state. Simply you can remember, for becoming a member of Legislative Council, elected for a Legislative Assembly, you need to be an elector in a concerned state. For this particular part, nomination part, idea is resident. There's a difference between elector and resident. It may be possible I'm an elector added in voting list of different state. But for past few years, I'm living in this state, different state. So I can be nominated. It may be possible that my name is yet to be added, but since I'm a resident here, I can be added. Alright? He must be a member of scheduled caste, scheduled tribe if he wants to be contest a reserved seat. However, a member of scheduled caste, scheduled tribe can also contest a seat of other, general category. This is obvious. Disqualification, office of profit, unsound mind, or when charges of unsound mind, then that person should be declared so by the court. Undischarged insolvent, it means that person is on the verge of bankrupt, has gone bankrupt. It means now this person cannot be trusted with the public money, responsibility. Not a citizen of India, voluntarily acquires foreign citizenship, then your membership is going to go. Is disqualified under any law made by Parliament. Any law, for example, Representation of People Act law. He must not have been found guilty of certain election offences, same as in case of Lok Sabha, Rajya Sabha. He must not have been convicted of any offence resulting in imprisonment for 2 or more years. I hope you remember the case of Lalu Prasad Yadav. I mentioned that when I was discussing Parliament. Detention of person, preventive detention law is not a disqualification. This can be a question scope. If you're detained under preventive detention, you're not going to be disqualified as an MLA. He must not be a director or managing agent holding office of profit in a company where government share is more than 25% or at least 25%. He must not have been dismissed from the government service for corruption and disloyalty. If someone is dismissed means removal on these charges, then that person cannot become MLA. Disqualification on ground of defection, same, anti-defection law. Means 10th schedule says Legislative Council, in case of Legislative Council, who is going to take decision of disqualification, anti-defection? Chairman. In case of Legislative Assembly, Speaker. Supreme Court ruled that decision of Chairman, Deputy Speaker in this regard are subject to judicial review. Means whether they have followed the proper rule or not. Now, vacation of seats. If double membership is there, you cannot be member of state legislature as well as Parliament. Disqualification we discussed, right? So disqualification grounds are 3. Same in case of Parliament, means Constitution, Representation of People Act, and anti-defection law. Absence, if you are absent from more than 60 days without any intimation, action can be taken. Resignation, if you have resigned. Now, attempt this question. Parliament by law may appoint governor of a state as the administrator of an adjoining union territory. Tell me that statement is true or false. The statement is false, although some of you might be referring to this part. This statement seems correct. But what about this? Parliament by law. You don't need a separate law by Parliament to actually give additional charge to a state governor as an administrator. Right? Second, if a governor of a state is appointed as an administrator for adjoining union territory, he shall exercise independently of the council ministers. Consider you are governor of, say, Maharashtra, and you are given additional charge as administrator of Lakshadweep. There's a charge of administrator there. That's a UT. So, do you think for your functions as administrator of that Lakshadweep, you need to take advice from Maharashtra Council of Ministers? No, right? So, that is why second statement is correct. Answer is B. As regards legislative powers, the governor of a state is not part of state legislature. The governor of a state has no emergency power to meet the situation arising from external aggression. Now, I hope you remember when we started this Parliament part, and I gave you example. In case of Parliament, it is Lok Sabha, Rajya Sabha and President. In case of state legislature, it is State Legislative Assembly. If there is Legislative Council also, State Legislative Council, as well as Governor. And first statement saying, as regard legislative power, Governor of a state is not part of state legislature. How can it not be a part of state legislature? No bill can be turned as act without sign of Governor, at least presented before Governor. One way is presented to President. But the point is, Governor is an essential part of state legislature. And this part is correct because no emergency power is with Governor. So, second statement is correct. De jure head of the government is Governor. State government is Governor because de facto real head is CM. In which one of the following state, it is not constitutionally obligatory to the Governor to appoint minister in charge of tribal affairs. That's a factual part we discussed in the start. In an election to a state legislative assembly, a candidate is declared defeated, lost his deposit. It means zamanat zabt hona, means in which case it will happen. Candidate got failed to secure 1/6, even 1/6 of the valid vote polls, then it means even the deposit which you have given, that is going to be forfeited. Speaker of the Legislative Assembly is elected by the members of the Assembly. Same in case of Lok Sabha. Which one of the following is part of Electoral College of the election of President but does not, this question was asked by UPSC in Prelims, does not form part of the forum of impeachment. So, in case of election, member of Legislative Assembly elected, they are part, right? But when it comes to impeachment, do you think MLAs participate? No, right? In impeachment, it is just parliamentarians. So, it means answer is D, State Legislative Assembly. In previous lecture, we were discussing UPSC. Now, it's time for SPSC, State Public Service Commission. In our Constitution, Part 14, Article 315 to 323, talks about provisions related to UPSC as well as SPSC. So, SPSC is a constitutional body, a state-level recruiting agency, right? Starting from composition, our Constitution has not mentioned specifically how many members are there going to be in SPSC. So, the decision is taken by Governor on the advice of Council of Ministers of State, right? Chairman is appointed by Governor, right? On the advice of Council of Ministers at the level of state, right? And that maximum age can be 62 years and time is 6 years. In case of UPSC, when chairman was getting appointed, time period was maximum 6 years, but maximum age was 65 years. So, it's the difference. Now, when it comes to qualification, so Constitution has not specified qualification, okay? But at least half of the members should be from central government or state government, should have at least worked for 10 years. In case chairman's position remains vacant, for example, death happens or removal happens. So, in this case, acting chairman is going to be appointed by Governor. Now, please remember, in case of SPSC, appointments are being done by Governor, right? Governor of that state. But when it comes to removal power is in the hands of President. And this is a difference. Removal. So, who is going to do the removal? President is going to do the removal. Okay. So, this is an exception. If I make a statement, Governor of a state can suspend or has power to suspend member of SPSC or chairman of SPSC. Tell me that statement would be correct or not? True or false? Answer is true. Because here I use the word suspension. Suspension is temporary. For example, if removal proceeding means if a matter with respect to removal of SPSC member or chairman is with President and President has referred this misbehavior case to the Supreme Court. So, meanwhile, Governor has power to suspend that SPSC member or chairman. Suspension is temporary, right? Removal power is in the hands of President. I hope now you will remember it, right? If he is adjured insolvent, like in case of UPSC we discussed, there are 4 cases of removal. Number 1, if the concerned member or chairman is proved to be insolvent, that person's debts are so high that known source of income won't be sufficient to actually pay back, right? So, there can be a case of corruption as well in future. So, this person cannot be trusted, right? This can be a ground. Second, if that person engages into employment other than this, paid employment, this can be a case. If that person's mind or body is not serving, right? So it means person is not capable to do that job. So it means insolvency, employment, and infirmity of mind or body, right? Apart from that, the last case, that is misbehavior. What is misbehavior is not defined by our constitution. So in this case, president has to refer this matter to the Supreme Court. And whatever advice Supreme Court gives, that advice is binding on president. Some students, when reading Lakshmikant, they get confused here. If the Supreme Court, after the inquiry, upholds the cause of removal and advises so, the president can remove the chairman or a member. So some students think, oh, the word can is there. So it means advice may be binding or not. No, advice is binding. If you read after that, you will find in the second or third line that such advice is binding. Now, independence. First is, you cannot remove SPSC member or chairman apart from these four reasons. Means there is security of tenure, right? So one is security of tenure, then comes the financial part, right? So you cannot change the, you can say, conditions of service when that person is there. For example, if CM is saying appoint this person and in this position, and SPSC member chairman said no, we are people of integrity and we cannot appoint as this person has not cleared the exam, and we are not going to give undue favor anywhere in interview as anything. So now, so if this protection is not given, don't you think independence can be compromised, right? There can be a possibility that service conditions may be changed of that person, right? So now service conditions cannot be changed. You can actually work with full independence, honesty. Expenses are charged on Consulate Fund of India. Means they are not going to put to vote in state legislature again and again every year. Now, there are two statements and questions are asked from these two statements. So please read them carefully. The chairman of SPSC, on ceasing to hold office, is eligible for the appointment for the post of chairman or a member of UPSC. Okay. So chairman of SPSC cannot be reappointed on the same position, number one. If you are a chairman of SPSC of Uttar Pradesh, you cannot be, after completing your tenure, you cannot be again appointed for the same position. But you can be appointed as UPSC member or UPSC chairman. A member of the UPSC or the chairman of the other SPSC, but not any other employment. Means you can be means SPSC chairman can become member or chairman of UPSC, can become chairman of any other SPSC. Means you cannot be on same position, but you can actually become chairman of Rajasthan Public Service Commission, okay, if you were earlier of Uttar Pradesh, but not any other employment under the government of India or state. But you cannot be appointed in any other job under government of India or state, okay. Any job, no. And you can actually pursue your career later as a, say, private academician. That is your will. But you cannot serve in any other job under government of India or state. Clear? The chairman or a member of SPSC is, after having completing his first term, not eligible for reappointment for the same position. I have already told you this. Okay. Now functions. Number one is conduct the examination, right? For the state level exam. It is consulted on the matters related to personal management. What are personal management? For example, method of recruitment. For example, principles of promotion and transfer. Now, there can be a beautiful trap from this particular statement. UPSC might ask, in case of transfer of state government employees, it is mandatory on the government to consult SPSC. Okay. So if someone has read this and not understood it completely, the principle to be followed making appointment of civil service of the post in making promotion and transfer, that person might think, oh, I've read the transfer there. No, it is not saying that you need to consult SPSC for transfer. It is just saying principles to be followed, principle formulation. In that, you can say SPSC can play a role, okay, but it's an advising body, okay, playing on principles, not a regular transfers. Any claim for reimbursement of legal expense, for example, a state level government employee is facing some, say, charges and this court case going on, and this court case going on is in official capacity because some decision was taken by that person. So in this case, the person can say these legal expenses, please give me. Okay. Apart from this, if that person actually suffers some injury during the service, wants some pension, other benefits, so this kind of mechanism can also be suggested by SPSC. Supreme Court has held that if government fails to consult SPSC in these matters which we discussed, personal management matters, the aggrieved public servant has no remedy in the court. So a direct statement wise question can be asked. So this can be a statement. Okay. So SPSC need to be consulted, but if SPSC is not consulted, then you cannot go to court. Why SPSC was not consulted? Now, limitations. Same in case of UPSC, for example, in case of reservation for backward classes, it is not mandatory that you need to consult SPSC. In case of some claims which are leveled by SCs and STs, then also this SPSC can be excluded. Governor can also exclude SPSC in certain cases, service matters. But in such case, what you need to do, you need to present such proposals before state legislature. And state legislature can amend them or repeal them. These provisions are same as in case of UPSC. This power was with president there. Okay. Now role. So it is concerned with recruitment, right? Watchdog of merit system at state, like watchdog of merit system at India level, right? In case of UPSC. Not concerned with classification of service, pay, service conditions, cadre management. These things are not under SPSC. This is the limitation, because these things are taken care of by different department of personnel, right, which is responsible for cadre management and training, etc. Recommendations made by SPSC are advising in nature, means not mandatory. There is also a limitation. SPSC is consulted by governor for framing the rules, for example, provincial judicial civil service, PCSJ, provincial civil service judicial. So in this case, governor may consult SPSC that you have to conduct the exam, but we need to take High Court in the law, because High Court is having the power, right? SPSC is just an exam conducting agency and High Court is going to suggest that. So we are talking in case of provincial civil service judicial, right? PCSJ. Now let's discuss the case of JPSC. So JPSC is not a constitutional body. It's a statutory body. Please understand. Remember this, because there can be a question statement there. Can be created by an act of parliament. That's why we are saying it's a statutory. Request of the state legislatures concerned. If two state legislatures say to the parliament that we are not having capacity to conduct our own recruitment, and that is why we want support of center. In this case, an act can be made for actually making JPSC. Now, in case of SPSC, appointment was being done by governor, removal was being done by president. But in case of JPSC, although it is going to serve those two states or more than that, but in case of appointment as well as removal is done by president. But in case of age 6 years, 62 years, that is same as in case of SPSC. I hope you'll remember that, right? JPSC presents its annual performance report. Now, in case of SPSC, that is going to present its annual performance report before governor, and governor is going to present before state legislature. But if there is one JPSC for two states, so where this particular JPSC is going to present its report? It is going to present to the both governors, and then governors are going to present into respective state legislatures. Report to each of the concerned state governors. Each governor places the report before the state legislature. Now, so sometimes one statement is made from historical context. It was in Government of India Act 1935 that it was clearly mentioned that there will be a federal public service commission, which took the shape of UPSC later. There will be provincial service commissions, means state public service commissions, and there was also mention of joint public service commissions for 2 or more states. Okay, this is a fact. Now these are the articles 315 to 323 which talks about UPSC and JPSC, SPSC. Now attempt this question. On which among the following matters in the State Public Service Commission not consulted? Not, okay. Method of recruitment of civil service in the state is consulted. On the principle followed in making appointment for civil service state, principle, yes. On the principles to be followed in making of promotion, yes, principles, fine. Making transfer of civil servant, no. And that is why It is not consulted. D would be the answer. A member of State Public Service Commission may be removed by Governor, no. Governor, no. Governor, no. Because you know that SPSC members are removed only by President, right? In case of misbehavior, inquiry need to be conducted by Supreme Court, right? Joint Public Service Commission may be established for 2 or more states. If respective states agree in this regard, Parliament appoint JPSC Commission by law. Both are correct, A and B. And today we need to talk about governor. Part 6 we are starting today. We have completed part 5, that is union. It would be quite easy for you if you try to compare the dimensions which you have covered in President chapter. Since governor remain in news, saying that governor position has been misused by center to hamper the principle of federalism in Indian polity. UPSC has asked questions on governor in prelims as well as mains. So let's start governor. When we discussed the word parliament, so I told you that in parliament we include Lok Sabha, Raj Sabha and president, right? I hope you remember this. You remember this? Now, what about governor? So I told you why in the idea of parliament, president is included. Because parliament is there to make law. And there cannot be any law till the point president signs on that bill, right? It needs to be passed by Lok Sabha, Raj Sabha and then presented before president, right? Similarly, at the level of state, when we use the word state legislature, we have legislative assembly. In some states, we also have second house, that is legislative council. Along with them, we need to count the office of governor, then we can say that yes, this is a state legislature. Because bill is presented in assembly or council if there are 2 houses and then presented before governor. When governor signs, then it becomes an act in that particular state. So part 6, article 153 to 167, we talk about this state executive. Governor is the chief executive. It means all the executive actions of the state are taken in the name of governor. What does it mean? Many people have read this, but what does it mean? It simply means, consider a minister is issuing some policy, some directions. So on that file, the noting says that in the name of governor, such actions are being taken by state government, vetted by that particular department. And department head is, who is department head? At the level of minister, because policy actions are taken at the level of minister, right? Then implementation part is taken by the civil servants, right? So that is why governor is the chief executive head of the state, okay? Usually, one state used to have one governor. But after 7th Constitutional Amendment Act, this provision was changed and now one governor can be counted as governor of more than one state, okay? A state executive consists of governor, chief minister. I hope you remember, when we use the word union executive, I told you UPSC asked one question in prelims, that which of the following is not part of union executive, right? And one option was saying CAG, right? And that CAG was wrong. And some students were like, sir, how can CAG be wrong? Because CAG is executive, right? But that is not correct in the definition of union executive that is mentioned in part 5. Similarly, when we are using the word state executive, so you should not say, sir, if I am posted as a civil servant in state government, it means I am part of this permanent executive. So why I am not being counted as state executive? You will be counted as state executive, but not state executive in the definition mentioned in part 6 of Indian Constitution. Okay. So this definition says governor, chief minister, council of minister and advocate general. And in the part 5, what we discussed, president, PM, council of minister and attorney general, right? Nominational executive head. What does it mean? It means real power remains in the hand of chief minister and the council of minister. Governor remains the nominal head. Along with this, governor acts as agent of central government. Now you may be thinking, sir, why central government needs an agent to be in the state? Yeah, this point was actually raised in Constituent Assembly also. Then decision was taken that we know that in India there's huge diversity, right? And it may be possible some states may have secessionist movement, because the size of states and the population we have in Indian state, we have less than this territory and less than this population, we have nations in Europe. So it may be possible some state get inspired, no, let's actually convert the state into a separate nation, and some of them will have chance to become prime minister, right? So we cannot allow these kind of secessionist movements in India, right? It could hamper integrity of India, and that is why it was needed that state government should work as per constitution, right? There is one rule book of the whole nation, fundamental rule book, that is constitution, and that is why who is going to ensure that in state, governor is going to ensure that in state. Now some of you might be thinking, sir, how can governor ensure that state government is going to work as per constitution when you have said that governor is just a nominal head, real head is CM and council of minister, real power is in the hands of CM. The reason is, the moment governor discovers that this state machinery is not working as per Indian constitution and there is no way out at the level of governor, then governor can actually recommend president rule in that particular state. And then president rule means now state government will not have say. Now that state is going to be directly ruled in the name of president. And now president is going to ensure that this state is going to run as per Indian constitution, right? So I hope you got the logic. Why we needed an agent of central government in state as governor. Now appointment. So governor is appointed by president. So do we have some election for governor? No, we don't have any election. Consider you are Indian citizen and you are above 35 years of age. We are considering that you are above 35 years of age, and your name is presented to Honorable President by Prime Minister. Prime Minister said, sir, this name Shashank Tyagi, we want him to be made governor of Uttar Pradesh. Then President will say, okay, since this name has been recommended by Prime Minister and Council of Minister, okay, I am appointing that person, Shashank Tyagi, as governor of Uttar Pradesh. Okay, so this can be done by president. I'm using the word pleasure of president here. What does it mean? It means my position as governor is not having some secure tenure. Although it is said that there is a 5-year, means once I'm appointed and no one has removed me, no one means president has not removed me, then I can be on this position for 5 years. But this position is not secure. Any point of time, without any reason, president can remove me. It means I'm there for the pleasure of president. Now you may be thinking, sir, president seems to have a lot of power. No, that's not correct. Actually, president is doing that, means appointing as well as removing on the recommendation of Prime Minister and Council of Minister. Okay. Now, what about oath? So, Chief Justice or Senior Most Judge of the High Court are responsible for giving oath. For that, you can just easily remember this. Yes, I think it is visible to you. Yeah. Appointment and resignation means resignation / removal. Means consider that governor wants to give resignation. So governor is going to give resignation to whom? To president. Okay. But when it comes to oath will be given by Chief Justice of that High Court, or if Chief Justice is not there, he may be busy, he may be ill. So at that point of time, the senior most judge of that High Court is going to give oath to the governor. So please remember this. These kind of facts are also asked by UPSC. I think this is clear to you now. Now coming to the conditions of the governor's office. First of all, he should not be a member of House of Parliament or state legislature. It means you cannot remain member of parliament or member of state legislature and simultaneously you want to become governor. Okay. Now I'm making a statement here and you have to tell me that statement is right or wrong, because there's a scope of question there. The whole thing is written before you. Okay, you can read it out and then answer me. Okay. So statement is, any sitting MLA or sitting MP's name cannot be recommended for the position of governor by Prime Minister, Council of Ministers, full stop. It means it can be recommended only after resignation has been accepted of the concerned person from the House. Now tell me that statement is true or false. So those who are not able to concentrate on it, just pause the video, think on it, or just go back and listen to what I've said. I'm saying that consider you are an MP or state legislative, means member of state legislature. Your name cannot be recommended for the position of governor till the point you leave that seat. Some of you would say, sir, that is true. That is written here. He should not be a member of either House of Parliament. Acha. Do you think both things are same? No. Name can be recommended for the appointment of governor, even if that person is a member of Parliament or state legislature. But the moment that person is going to be appointed as governor, he will cease or she will cease to be on the position of MP or MLA. And that is what is mentioned here. Just read it. If any such person is appointed as governor, is deemed to have vacated the office, so then it will be considered that that person has vacated that house on the date on which enters upon office as governor. So it means it will be considered the date that person enter into office of governor. From that date it will be considered now this person is not member of Parliament or state legislature. So if you got it now, mention got it. Clear? Now, second, he cannot be arrested or imprisoned. I remember a case when Ms. Sheila Dikshit was governor of Kerala, and there was a CNG scam which was in news, and CBI was investigating. So now investigation was on, and CBI court was saying, and there were news that it may be possible that a direction for arrest may be raised, means conclusion, means proofs are of such level. But Constitution was saying something else. Constitution was saying you cannot imprison, you cannot arrest a sitting governor. Then what could be done? Considering the seriousness of that particular case, the concerned president, on the advice of Prime Minister, Council of Ministers, can remove that person from the position of governor, and then you can arrest that person. But till the time he or she is on this position, you cannot imprison that person. Okay. Along with this, any action which has been taken in official capacity for the official purpose, you cannot actually raise proceedings against that person, because that actions are having immunity. Why? Because most of the actions of governor are on the aid and advice of Council of Ministers, right? And if any action is unconstitutional, invalid, then court is there, na? High Court is there, Supreme Court is there. They can review that particular judgment, they can review that particular direction, they can review that particular order, and they can declare that ultra vires or null and void, right? But in case of civil proceedings, means after giving 2 months notice, civil proceedings can be instituted against him during his term of office for personal acts. So only for personal acts, civil proceedings can start. Civil proceedings means any matter with respect to tax, family matter. So those proceedings can start. Okay, but 2 months notice need to be given to the governor so that governor can prepare and finalize all the pending works, responsibilities with respect to that state. That is why these provisions were added in our constitution. You should understand the logic. Now, when the same person is appointed as the governor of 2 or more states, what is going to happen? Who is going to pay the salary? Consider a governor is appointed for a single person is governor for Maharashtra and Andhra. Now, who is going to pay the salary? Now, you would say, sir, anyone can know. Both states would say, why we should pay the full salary, full allowance, when that person is also working as governor of other state. So now you should split the expenditure, right? Like you do in your parties with friends. Emoluments, allowances payable to him shared by the states in such proportion as determined by president. Now, the allowances, the salary is going to be splitted. Okay, it's going to be shared. That is correct. But please remember, UPSC can play on this. Who is going to determine what portion is going to be given by what state? This determination is not going to be done by one state or other, because they cannot agree on one thing, right? One state can say, sir, I'm a small state, why should I pay half salary? Other state is bigger state, so many cases, so many files, that state should give more. So that is why regarding this, that condition will be determined by president. Okay, there then can be a scope of question here. Please remember it. We are doing operation of every provision of this chapter. Now qualification, as I told you, 35 years of age and you're an Indian citizen, it means you are fit to become governor, right? But you need kripa of Prime Minister and Council of Minister for that. No education qualification is there, no maximum age is there. Even if you are 110 years of age, God bless you. If your name is recommended for the position of governor, you can be appointed on this position. Now, over the time, some conventions have been actually developed. Conventions means these things are not mentioned in constitution, but these things have been followed considering these are good. For example, if you take a look, governor of UP, governor of Rajasthan. So governor of Rajasthan is actually a resident of UP. So most of his life, active political life, he was residing in Lucknow, UP. So he was appointed as governor of Rajasthan. Governor of UP, she was actually a politician, seasoned politician in Gujarat. So the logic is that if a person from outside is actually appointed on the state, it is less likely that person will be considered as a political person, because governor position should be neutral. So he should be an outsider who does not reside in the state where he will be appointed or she will be appointed. Another convention which was raised was that when you appoint governor, and since governor has to work in close tandem with the CM, then chief minister of that particular state should also be consulted. But this convention remains convention, matlab, this is not mostly followed, and that is why many CMs have raised this matter. But this convention is mostly followed. Okay. Now oath, I have already told you, oath, CJ or J. Now terms of office of governor does not lay down any grounds upon which governor can be removed. As I told you, if you are a governor of any state, say Maharashtra, and the next day you receive a fax from the president office that Mr. Rohit, from this date, now you are removed from the office of governor, you just pack your bags. So you cannot do any if and but. Why I am being removed? I'll go to the court. Then court will say, beta, you should read governor chapter from Lakshmikant, right? Because governor cannot question this, because governor position is there on the pleasure of president, right? And there are some cases with regard to this. National Front government headed by VP Singh in 1989, what VP Singh did, so he read this particular provision. He said, now I am giving a direction that Prime Minister is actually giving a direction. So Prime Minister cannot actually remove governors. Governors can be removed by President. Prime Minister can recommend President, right? So VP Singh asked all the governors to resign. That you yourself resign, otherwise I'll recommend to the President and President is going to remove you. So you should resign as you were appointed by Congress government. But after that, what happened? Eventually some of the governors were replaced and some were actually continuing that position. After that, when next government came in 1991, PV Narasimha Rao government, it means Congress government, then they changed 14 governors appointed by VP Singh government, Chandrasekhar government. So the point is that the central government removes governor from the previous government, right? And there has been question on this, that there should be some ground of removal also. Then only governor will actually act in neutral manner. Some of you would say, sir, what is the harm? Just remove them. What is the harm? Harm is that if governor knows that I have to be in good books of the Prime Minister and Council of Minister of the Union, then what they can do, they can actually misuse this provision of Article 356 of Indian Constitution, means President rule. Means if the party in power wants a different party's government in state to be quashed, so they would like to actually install a governor who is going to actually dislodge that government. So that is why Article 356 President rule has been misused many times, and governors were misusing them for their own security because they wanted to remain in this position of governor, right? President may transfer a governor, appoint to one state to another, right? Further, a governor whose term has been expired may be reappointed. Now, my question is, consider you are a governor and you have completed 5 years there. Now, can you be reappointed in the same state, or you need to be, if you are being reappointed, you need to be reappointed in different state? Since our constitution is not saying anything about it, that is why you can be reappointed in any state, in the same state as well. Okay, please remember it. You have to read between the line. Okay. In case of the death of sitting governor, who is going to be working as a temporary governor? Chief Justice of that High Court is going to be appointed as temporary governor for that time by the Honorable President. Please remember it. Okay. Chief Justice of that High Court. Now, coming to the power and functions of the governor. Let's simplify executive power. You can easily remember these power by understanding this logic. Executive means implementing law. For example, there is a law regarding appointment and governor is just following this law, executing this law. It means this is executive power of governor. For example, appointing chief minister, council of minister, appointing advocate general means topmost legal officer of state government. So these appointments are done by governor and these come under executive power of governor. Along with this, governor can also appoint a state election commission. Now there's a trick here. UPSC might say that appointment of state election commissioner and appointment of chief minister comes under executive power of governor, and these positions are there on pleasure of governor. Now tell me that statement is true or false. Come on. Should I repeat, or you can pause and go back? I'm saying appointment of chief minister and state election commissioner are executive powers of governor, comma. These positions or these people serve there on the pleasure of president. So half statement is written before you and other half I have made up, that they serve on the pleasure of president, pleasure of governor, I'm saying. Now tell me that statement is true or false. Pleasure of president is obviously wrong. And if I'm saying pleasure of governor, now tell me that statement is true or false. Some students would say, sir, it is correct. Because chief minister is not having any secure tenure. Someone can be on this position of chief minister only till the point that person is having majority support in state legislative assembly. When more than 50% of the state MLAs are supporting that person as leader, then only governor appoints that person as CM of that state, right? Now the point is, the moment that person loses that confidence in the state legislature, governor is going to remove that person. This may be after 6 months. So removal can be done by governor. It means this position is connected to pleasure, although condition is there. Till the point majority support is there with the CM, with the CM, then governor cannot remove that CM, right? Now, what about state election commissioner? So twist is, when it comes to these positions, CM, council of minister, advocate general, they are there on the pleasure of governor. But when it comes to state election commissioner, so this position is not there as per pleasure of governor. Okay, so this is exception, and UPSC play on exception, right? So executive power, all executive actions of the government of state are formally taken in his name. As I told you, in the file, actions are taken in the name of governor. Now, what process is going to be followed while you actually approve these files, it can be decided by a governor on the advice of CM, council of minister, obviously. Appointment of CM ministers hold office during the pleasure of governor, as I told you in that question. So this is executive power. And what is this actually? Now, council of ministers are appointed by governor. But which person is going to give in which ministry? How many ministries are going to be there? Is sole power of CM, Chief Minister. Chief Minister recommends to the governor and governor do that. Then in these states it was considered mandatory that tribal welfare minister need to be there. Chhattisgarh, Jharkhand, Madhya Pradesh, Odisha. State of Bihar was excluded from this list. Okay. Now second, emergency provisions. Article 356. President can actually, governor can recommend president rule in that state. So that is also what? Executive power. Because law is already there. Governor is just executing that process. And if in this condition, means if these recommendations are accepted by president and president rule is imposed, now governor would be like, now extensive power is with me. Who is CM now? Right? So it means extensive executive power will come in the hands of governor if president rule is imposed. Then take information from CM regarding the legislative actions which they are planning, the bills they are planning regarding administration. Governor can ask CM. CM works as a bridge between Council of Minister and governor. You may have heard about some issue which was going on in Tamil Nadu when governor actually took meeting directly with some district officials. So it was said that governor should not meet directly with district officials. Governor should not question even the ministers directly. Governor should seek information from CM. So this I have already explained to you. Advocate General appointed by governor. Imposition of president rule. Appoint state election commissioner. How state election commissioner is removed? The state election commissioner can be removed like the same manner on the grounds of judge of a high court. Such is the importance of state election commissioner. And why it is given? We are talking about democracy, and in democracy, free and fair election is the primary feature. And how you can ensure free and fair election? The key official in a state should be the neutral one, should be free from any bias. So that person should be given this security. He can seek any information relating to administration. As I told you, seek information. This. So I think broadly, if you remember this, then it would be cakewalk for you. I hope it is clear to you now. Now attempt this question. Who can remove chairman of state public commission? Although we are going to discuss these later, but you should connect them simultaneously. Topics are interlinked. Yes. President, Governor, Chief Minister, Chief Justice of High Court. Some of you might be thinking, sir, remove Chairman of State Public Service Commission. Okay, so State Public Service Commission, we are talking about state. So that person should be removed by Governor, right? But that is wrong. Answer is President. Governor appoints Chairman and members of State Public Service Commission. It is executive power, however, removed only by president. And question was asking, remove. So please remember, okay, appointment by governor, removal by president. Legislative power. So legislative power means power of governor with respect to house. Whatever happens in house, in this regard, governor is given certain responsibilities. For example, to call the session. Session will start only when governor summons the session on the recommendation of CM, Council of Minister. So summoning the session is legislative power of governor. Then governor is there to prorogue the session, same like president is there to summon and prorogue the session of parliament. Prorogue means end the session. Like I told you in president chapter, president is there to address the house in the first session every year, right? As well as after general election, first session, right? Similarly, at the level of governor, address the house in the first session, means after every year, as well as after new elections, right? Fresh elections. Send message to the house, asking them that these legislative proposals are important, do please consider them. As well as disqualification. Yes, that is also legislative power. So in what case governor has power to disqualify? Whose disqualification we are talking about? We are talking about disqualification of state legislative assembly members, members of state legislature. As I told you in parliament chapter, there are three broad categories on the basis of which a member of state legislature or member of even parliament can be removed. One category is mentioned in constitution, other representation of people act, and third 10th schedule, that is anti-defection law, right? When it comes to anti-defection law, the decision to remove disqualifying that person lies with presiding officer of that house. For example, if you are talking about disqualification in state legislature on the basis of anti-defection law, then decision will be taken by Speaker of State Legislative Assembly. But when it comes to Constitution, Representation of People Act, where primary investigation is done by Election Commission, the Election Commission is going to recommend to the governor, sir, please remove this MLC. Then that is also a legislative power of governor. So please remember, appointment power in executive power, disqualification in this legislative power, disqualification of MLA. Okay. Now, presiding officer means who is going to be the presiding officer in case a speaker and deputy speaker of the state legislature are not there. So who is going to decide? Governor is going to decide. Similarly, there also president can act, although there is a panel also there. Ordinance making power is also legislative power of governor. Ordinance, what are ordinance? I told you, Article 123 in case of president, Article 213 in case of governor. In case either house of parliament is not functioning, it means there's no condition where this can be made, this important law can be made, since house is not functioning and there's immediate action which is needed. So this bill can be turned into a temporary law in form of ordinance by governor, right? So that is also legislative power. Nominate 1/6 member in state legislative council. Similarly, in case of president, 12 nominated members in Rajya Sabha. I hope you remember, right? Similarly here, 1/6. Now I think this will be cakewalk for you. Means this is what we have discussed, right? One thing you should remember. This is the same case. Promulgate the ordinance, but once House reassembles, you have to get it passed within 6 weeks from its reassembly. Same. Nomination, there's another condition called cooperative movement. It means 1/6 members are nominated from which category? Literature, science, art, social service, along with this cooperative movement. Okay? When a bill is sent to the governor, after it is passed by state legislature, he can consider a bill is presented before governor after it is passed by state legislature. What can governor do? Governor can give assent. Assent means now this bill will turn into an act. Governor can withhold. It means now done. This bill is not turning into an act. Governor can return. Means send the bill back to the house for reconsideration. But once house says, no, we are not amending anything, we are agreeing that this bill is correct, now governor has to sign this. Okay? Same as the case of president. Now, there is additional fourth function with governor which is not with president. That is, reserve the bill for president. So these are the 4 categories or 4 choices which governor has when a bill is presented before governor. I hope you will remember it. Now, financial power. This we are going to use also because now we are going to compare president and governor also. These things are going to get embedded in your mind, don't worry. Now, financial power. In case of president, I told you, budget is presented in Lok Sabha with prior recommendation of president. Similarly, in case of state government budget, it is presented in state legislative assembly on the prior recommendation of governor. So that is financial power. Like I told you, no grant, no demand can be made except on his recommendation in case of president as well as in case of governor. Money bill is presented in Lok Sabha with the prior recommendation of president. Similarly, money bill is presented in state legislative assembly on the prior recommendation of governor. He can make advances out of contingency fund. Similarly, we have contingency fund at the level of president also, contingency fund at the level of state also. Constitutes finance commission, but this finance commission is state finance commission. It is there to decide how much resources need to be distributed between state government and municipalities and these panchayats. Okay. Now I am asking a question and you have to tell me the statement is true or false. Finance Commission. When I'm saying just Finance Commission, it means I'm talking about union level Finance Commission, which is actually constituted by Honorable President. Finance Commission can also recommend ways by which panchayats or municipalities should supplement their resources. Means Finance Commission at the center can give recommendations to state for enhancing the resources for municipalities or state municipalities or panchayats. Tell me the statement is true or false. Answer is true. Although we have State Finance Commission for that purpose, but Union Finance Commission, Union Level Finance Commission can also recommend the same. Clear? UPSC has asked these kind of questions. Now, judicial power. I hope you remember in President chapter we discussed pardon, reprieve, respite, remission, right? Same judicial power are with governor, but there are some differences and their questions are asked. For example, take example that in case of death penalty, so president has power, this judicial power, to actually pardon death penalty. When I say pardon, pardon means absolving that person from any conviction. It is like Ja Simran ji le apni zindagi. No case, nothing. Go home. That is pardon. When I say commute, there we discussed that now we are reducing the amount of punishment, right? So president can pardon death sentence, but governor cannot pardon death sentence. Okay? Means governor cannot say a person with death sentence, just ji le simran apni zindagi, right? Cannot completely absolve that person from conviction, but can use respite and reprieve, these kind of things. Okay? Another thing, with respect to court martial, president has power, this judicial power can be used. But in case of court martial, means military court's decision, governor's actions are not going to be used. Okay, so these two differences you should remember. Apart from this, he makes so you can easily remember this. First of all, appointment and transfer in subordinate judiciary, it means district court, municipal court, right, session and the civil courts. So appointment of judges at this level is done by governor, obviously on the recommendation of State Public Service Commission and State High Court, right? Transfer is actually chiefly done by State High Court, but State High Court give recommendation, right? Governor do that. So prime power is with State High Court, but governor do that, right? So make appointment, posting, promotion of district judges in consultation with State High Court. Please remember, posting, appointment and promotion. Okay? Appoint person to the judicial service of the state, appoint. So just remember, appointment, posting, promotion. You can remember it like this. Remember this mnemonic: appointment, posting and promotion. Okay, postings means changing one position to other position, right? I think this is clear to you now. Now, let's compare president and governor. So with regard to ordinary bill, if a bill is ordinary bill is presented before president, what choices president has? President can give assent, withhold and return. If it is returned once and it comes back again, then president is bound to sign. With respect to governor, governor has fourth option as well: assent, withhold, return as well as reserve. Reserve the bill for president. Now president has reserved the bill. Now governor has reserved the bill for president. Now what president can do? Means now this bill is reserved for president. Here is we have governor. Okay. Now what choices president is having? President can give assent. If gives as assent, it means now this state bill can be turned into a law, right? Can return. Return means you have to return. Now when you return, there's a condition. Condition is that concerned state legislature has to consider this bill within 6 months time and send this bill back to honorable president. Okay? Withhold. So it means assent, withhold and return. So all three conditions which are with president in normal conditions are with president in case of reserved bill of state also. But here just one thing you need to remember: 6 months time is there with state legislature. In normal conditions, with the bill, when the bill is of parliament, means Lok Sabha, Rajya Sabha, no such 6-month condition is there. But on reserve bill, 6 months condition is there because this bill belongs to state. Clear? Please remember, when this reserve function is used by governor, now governor has no role with respect to this bill. This bill will directly go to that particular, means this bill is going to be presented in that state legislature, and when state legislature is going to send back, this bill is going to be presented before president. Now no role of governor in case of reserve function is used. Clear? With regard to money bill, what choices president has? President can give assent or withdraw, withhold. Means president cannot return this bill because money bill is actually presented in Lok Sabha on the prior recommendation of president. Normally president gives assent to the bill. In case of governor, governor has 3 powers: assent, withhold and reserve. Please remember, one thing is common: return function is not used by president as well as governor in case of money bill. Return function is not used. UPSC is going to make statement on this. You need not to fall into trap. Okay? Now, consider reserve function is used. President has sent, now president is taking up this bill, state bill, as governor has sent this bill. Now what options president has? President can give assent to the bill. President can withhold bill. Return function, as I told you, is not going to be applicable in case of money bill. So the president cannot return money bill of for the reconsideration of state legislature. Clear? So please, it is quite easy now. And similarly, as I told you, once reserve function is used, governor has reserved the state legislature bill for the president. Now governor has no role. Now it is between president and that state legislature. I hope it is clear now. It is quite simple. It means while you're reading, it seems like so many words, but you need to just pick up the logic. Comparing ordinance making power of president and governor. Please remember, first of all, in which case ordinance can be used. If one house or both house, means either house is not in session, then president as well as governor can exercise this power of ordinance on the recommendation of prime minister headed by council of minister, means council of minister headed by prime minister in case of president, and here CM, right, heading COM. He can promulgate ordinance only when he is satisfied that immediate action need to be taken. He is satisfied immediate action need to be taken, although works on the recommendation of council of ministers. So it is also same. So both is same. Now his ordinance making power is coextensive with legislative power of the parliament. It means ordinance making power of president is applicable on laws on which parliament has power to make law. Okay. Some of you might be thinking, sir, it is too obvious. Acha, it is too obvious. Let me ask one question from you. Ordinance making power of president is applicable only on union list. Now tell me that statement is true or false. I am repeating my statement. Ordinance making power of president can be extended only till union list or concurrent list. Okay. Tell me the statement is true or false. Some of you might be saying, sir, it is true. Since you are saying can make law only on subjects where parliament can make law, right? Achha. I am reframing this statement again, and then I am going to tell you the right answer. Now the statement is, ordinance making power of president cannot be extended to state list. Means president cannot make ordinance on a subject which is mentioned in state list. Now tell me the statement is true or false. Some of you would say, sir, it is false, because it is clearly saying his ordinance making power is coextensive with the legislative power of the parliament. This means that he can issue ordinance only on those subjects on which parliament can make law, right? My friends, both the statements which I have made are wrong. Answer is false. Now some of you might be thinking, sir, then this is what is written here is wrong. Is Lakshmikant wrong here? No, Lakshmikant is right. You are wrong. You are misunderstanding. You're not listening to me. You are relating to things with your own preconceived notions. Let me prove you how. Here statement is saying President's ordinance making power can be extended only on those subjects. Word only is used. Only on those subjects where Parliament can make law. Right? And the statement which I have made, in which I am saying only union list and concurrent list. First statement, that is wrong. The reason is, in special circumstances, Parliament can make law on matter mentioned in state list as well. And that is why both statements were wrong. Because Parliament can make law in union list case, in concurrent list case. But the statement was saying only, no, not only, because Parliament in special case, in a case of emergency, can make laws on matter of state list as well. So that is why in that case, ordinance making of power of President in that special case extend to state list as well. If you got it now, mention "wa" in comments, because I have saved you from a trap which UPSC is going to make in exam, and many students are going to fall in this trap, but you are not going to fall. Clear? His ordinance making power coextensive only extends to matter on which state legislature can make law. Should I play along this point as well? Chali, I am making another statement. The statement is, governor's ordinance making power cannot extend to union list. The statement is true or false? Tell me. Answer is true. Because there is no case, no emergency case in constitution where state government or state governor can actually make law on a matter mentioned in union list. ये तो औकात से बाहर की बात हो जाएगी. That would be way beyond the ambit of state legislature. Right? I hope this is clear to now. An ordinance issued by him has same force as an act of parliament. Similarly, an ordinance issued by governor has same power as law made by state legislature. Ordinance issued by him subject to the same limitation as an act of parliament. This means ordinance issued by him can be made invalid. Means judicial review will be applicable here also, and judicial review will be applicable here also. Okay? Can withdraw ordinance at any time. Similarly, governor can also withdraw any time. Ordinance making power is not discretionary, has to act on the aid and advice of council of ministers. Similarly, not discretionary, has to act on the aid and advice of council of ministers at state. Ordinance issued by him should be laid before both the houses when it reassembles. Same cases here. Within 6 weeks, same cases here. Within 6 means no instruction for the making of ordinance. In this case, instructions are that in case any bill which is presented before state governor by the Council of Minister of State, which has certain provisions in which this matter need to be referred to the president, then that matter need to be referred to the president. It means no ordinance should have provisions which are in conflict with central government. Now, pardoning power, as I told you, is applicable on central law, applicable on state law in case of governor. Only authority who can pardon that sentence is president. And governor cannot actually pardon that sentence, but governor can suspend, remit, commute that sentence. Means temporary. Suspension means temporarily, means now death penalty is actually delayed. That can be done by a governor. Governor cannot say, Ja Simran ji le apni zindagi, or completely absolved. No. Can grant pardon, reprieve in case of court martial, but in this case, no court martial. Means court martial case cannot be taken by governor. Right? So I think it is clear to you now. The difference is clear. So these are just articles, you need not to cram them. These are some factual questions because we have played around the traps of this chapter. You are confident about it now. But UPSC sometimes are asking one or two statements on facts as well. Which of the following first Lieutenant Governor of Ladakh? Ladakh is in news. R.K. Mathur. First women Governor of State in Free India? Sarojini Naidu. Yes, this is a good question. Which one of the following statement is not true with respect to governor? Not true. They are part of state legislature. This is true. They can forgive the death penalty. This is not true. You got the answer. B is correct. Which of the following power is not vested in the governor of Rajasthan? So since Rajasthan governor was in news, so you should not think UPSC can play around this point, and some of you might think, oh, governor of Rajasthan must be having some different power. That is why governor of Rajasthan word is used, and that is not correct. Just read the statement. To summon the assembly, it is saying not vested. Summon the assembly, yeah, this power is with governor. Adjourn the legislative assembly. Adjourn power is not there, because adjournment power is with speaker of state legislative assembly, right? Presiding officer. So it means this is the answer. Dissolution and prorogation are power of governor, right? So this is the answer. Second, I think that is correct. Now it is clear to you. So I hope now you are confident about governor chapter. If you find any difficulty, any kind of question, you can shoot me a message on my personal Insta handle, shashank.powerbeing. I'll be more than happy to help you out. This PDF will be available in the Shashank Tyagi For You Telegram group. See you in the next video. Hello and welcome everyone. I hope this message finds you fit and fine. We are in video number 50 of our Lakshmikant series Kanthas, and today we need to talk about State Legislature 2. Means we have discussed other half in the previous video. I want you to recollect what we discussed in case of Union Legislature. Let's start with presiding officers. In case of Lok Sabha, I hope you remember Speaker and Deputy Speaker. Same is the position in case of State Legislative Assembly. If State Legislature is having two houses, means bicameral legislature, then the same format. Like in case of Rajya Sabha, we have chairman and deputy chairman. Similarly, we have in case of State Legislative Council, chairman and deputy chairman. If these two presiding officers of the both houses are absent, who is going to preside the house? We have a panel in both houses, right? In case of Union Legislature, in case of Lok Sabha, we have panel of chairperson. In case of Rajya Sabha, we have panel of vice chairperson. Same is the format in case of State Legislature, right? Now, Speaker of the Assembly. A Speaker is appointed from among the members, I would say elected from among the members of the State Legislative Assembly. He vacates his office in which of the following cases? Number 1, ceases to be member of assembly. If you became speaker, but now you have resigned or you got disqualified as member, it means now you will not be considered as speaker anymore. Resigns, and whom is going to resign? Resignation will be given to deputy speaker. You can easily remember it. A speaker is going to give resignation to deputy speaker is going to give resignation to speaker. Okay, and same is the format in case of Legislative Council. Chairman is going to give resignation to deputy chairman, and deputy chairman is going to give resignation to chairman. Easy, right? If he is removed by resolution, and which majority is needed? Effective majority. All the then members of the assembly, means vacant seats are not going to be included. Same is the case of Lok Sabha, Rajya Sabha. 14 days prior notice need to be given if you want to remove this speaker via this resolution, right? Now, powers and duties, same format. What is the power? Maintain order and decorum in the assembly. Final interpreter of constitution within the house. Rules of procedures and conduct. Legislative precedents within the assembly. So all of these functions are taken care of by a speaker. He adjourns the assembly or suspends the meeting in the absence of quorum. It means the minimum number of members which are required to conduct the proceeding, that is 1/10. For example, if there are 100 members in the house, that is the total strength, then you need at least 10 members to conduct the proceeding. If even these number of MLAs, or in case of Legislative Council MLCs, are not present, then presiding officer will say, I am not going to conduct the meeting. Okay? He does not vote in the first instance because you are the presiding officer. You need to act neutral. But in case of tie, you can vote. That vote is going to be called as casting vote. Okay? He can allow a secret sitting. It means members other than the members of the house are not going to be allowed, right? It can happen, right? Media is not going to be allowed. So secret sitting can be allowed by presiding officer. This power is with presiding officer. He decides whether a money bill or not. Means Council of Minister of State is going to present a bill before Speaker of Legislative Assembly. Sir, please declare this as money bill. And he will see, okay. I am declaring it. So only presiding officer, or you can say Speaker of Legislative Assembly, is having power to declare a bill as money bill, and his decision is final. He decides the question of disqualification in case of anti-defection. You are a member, where it is found that you have defected to other party, means under 10th schedule, you need to be disqualified. Who is going to take the final call? Presiding officer of the House. In case of Legislative Assembly, a Speaker is going to take the decision, right? Now tell me, what if you are a MLA, but you have flouted some rule which is mentioned in Representation of People Act, or you have flouted some rule which is mentioned in our Constitution. For example, you took citizenship of other country. Now, who is going to remove you? In that case, Governor of the state is going to remove you on the recommendation of Election Commission. I simply told you there are 3 pillars of removal, disqualification. In one pillar only, that is anti-defection law, presiding officer of the House holds the power. In other 2, Governor, and at the level of Union, President, on the recommendation of Election Commission. And my friends, if question is asked by UPSC whether in these 2 cases recommendation of Election Commission is mandatory or not, it is mandatory. Whether such recommendation and such decision by President or Governor in case of state can be considered under judicial review. Tell me, answer is true or false? Answer is true. For example, case of 21 Aam Aadmi Party MLAs in Delhi. So they were declared disqualified by President himself because it's a UT, not a complete state. And Delhi High Court put a stay there, right? It can be under judicial review. So it means you have to keep your eyes and ears open. What is happening? And just grab the provision part of polity, which is in news, right? He appoints the chairman of the committees of the assembly and supervises the functioning. 3 committees, please remember, himself the chairman. Business Advisory Committee, same in case of Lok Sabha Speaker. Rules Committee and General Purpose Committee. It means just remember what we discussed in Lok Sabha and it can be replicated here also. He can allow secret sitting, as we discussed. Deputy Speaker of the Assembly. Deputy Speaker, another position. This is also elected one. It's not like Speaker of Legislative Assembly has actually given this position to someone. It's not a nominated position. Please remember that. Usually remains in office during the life of the assembly, vacates in these 3 conditions, same. Means ceases to be a member, resigns to speaker, or removed by resolution. All the then members. It means same majority. 14 days notice. So CRR 14. Please remember, when it comes to presiding officers, whether Lok Sabha, whether in this state legislature, whether speaker, deputy speaker, chairman, or deputy chairman, this 4 conditions you need to remember. That's it. Deputy Speaker performs duties of the Speaker's office if Speaker is not in the House. Also acts as Speaker when later is absent. Speaker nominates from amongst the members a panel of chairperson. That's a separate panel, right? For the purpose, if both are not present, then someone from the panel is going to preside, right? One among them. And same power as the Speaker is going to be held by the person who is presiding the House. Now, Chairman of the Council. Means chairman vacates his office in any of the 3 cases. Means we are talking about Legislative Council. Okay? Vidhan Parishad. Ceases, resigns, removed by the resolution by a majority of all the then members of the council. Such a resolution can be moved 14 days. Presiding officer powers and functions as the same as case of Legislative Assembly. It means you have to conduct the proceedings of the House as per the rules and process. You are going to decide which agendas are going to be taken first, which later, which person is going to given preference for actually speaking out. However, the Speaker has one special power, that is money bill. Only Speaker can decide whether a bill is money bill, not chairman. They are charged on consulate fund, means expenditure on these houses is charged on consulate fund of India. It means you are not going to put this to vote or to put this to discussion and vote how much you need to give this year. Deputy chairman, same. Ceases, resigns, removed, 14 days notice. Performs duties of the chairman's office if chairman is absent, means vacant. Acts as chairman when absent. Tell me if there's any difference between these words vacant and absent. Yeah, there is. When I say vacant, it means no one is representing that particular seat. But when I say absent, absent means that person is not there, but someone is there on that position. It may be possible that person is ill, that person is not present due to some jobs elsewhere, right? This is the difference between absent and vacant, right? In vacant case, you have to appoint, elect or nominate some other person there. But in case of absent, no, that person, someone is representing that position, right? Chairman nominates from amongst the members a panel of vice chairman. Any one of them can preside. Now, sessions of state legislature. First of all, you have to call the session. Calling the session is called summoning. Who summons the House? Governor, on the advice of Council of Ministers. And what is going to be the maximum gap? Maximum gap can be 6 months between two sessions of state legislature. In case of adjournment का मतलब है that within the proceeding, means consider House has started and within this time, House is ending here. This is ending, this is starting. Within that, you can adjourn the House for 2 days, 3 days. Who can decide that? This can be decided by presiding officer, not by the governor. Please remember that. Adjournment signed by, it means now we are at this stage and now presiding officer saying that we have completed the agenda of this session. Now, sir, we are doing adjournment signed by. It means I'm saying that yes, these MLAs can go back. We are not holding session and I'm not declaring the time when the session is going to be held again. And now this is an indication to the governor, and governor can actually say, okay, I'm proroguing the session. Means session itself is going to end now. Now, dissolution. Legislative Council is a permanent house, right? You cannot dissolve Legislative Council. Same is the case of Rajya Sabha, right? Only Legislative Assembly can be dissolved, okay? Unlike the prorogation, a dissolution ends the very life of existing, means Legislative Assembly. That can be asked as a question. Why? Because when I say prorogation, it means governor is saying, "ठीक है, job is done. I'm declaring proroguing this session. Session is ending. Now I'm going to call another session." But when I say dissolve, it means the Legislative Assembly itself is getting dissolved. Now we need fresh elections. Okay, this is the difference between dissolving and prorogation. Position with respect to lapsing the bill. You remember the trick which we discussed in lapsing of the bills video in case of Lok Sabha? Same trick you need to remember. The trick was, consider legislature which is say bicameral. Okay, a bill is introduced in Legislative Assembly, and now that Legislative Assembly got dissolved. So bill will also dissolve, or you can say lapse. You are going to use the word lapse with the bill. Why? Consider that Legislative Assembly is getting dissolved. So Legislative Assembly has some shrap or sin over it. Okay. So now consider second case. Legislative Assembly passed the bill and now it is in Legislative Council. And now Legislative Assembly dissolved. What is going to happen? Bill is going to lapse. Why? Because this bill has already introduced in Legislative Assembly and that Legislative Assembly has having some shrap or sin. Okay, and protection can only be given when this bill touches Honorable Governor. That's a trick. Okay. So consider a third case. The bill is introduced in Legislative Assembly, also passed from Legislative Council, and now this bill is before Governor. And at this moment, Legislative Assembly dissolves. Now tell me, the bill will lapse or not? Bill is not going to lapse. Now this bill has touched Honorable Governor. That is third case. Fourth case. Consider a bill was introduced in Legislative Council. It has not been touched or introduced in Legislative Assembly. And Legislative Assembly dissolves. What is going to happen with the bill? Bill will remain. It is not going to lapse. Next case. Bill introduced in Legislative Assembly, passed from Legislative Council, presented before Governor, but Governor returns the bill for reconsideration in Legislative Assembly. And now Legislative Assembly dissolves. What is going to happen with the bill? Bill is not going to lapse. Why? Because it has once touched Honorable Governor. The security the boost has been given. Okay. So this is the easy way to actually remember this trick. Okay. And you are not going to mark any question wrong. Prorogation, I told you, who is going to do that? Governor is going to do that on the advice of Council of Ministers. If UPSC make a statement that Governor can adjourn the House, proceedings of the House, tell me the statement would be true or false. Some of you might be thinking, he is Governor. He may actually do this also. No, that's not possible. Because adjournment and adjournment sine can be done by presiding officer only, not governor. Governor start the proceeding and governor start the session and end the session. Within that, function will be taken care of by presiding officer. Within the next few days, means after adjournment sine within the next few days, prorogation is declared by governor. Our governor can also prorogue the house within session. Means even when adjournment sine is not issued by presiding officer, then also governor can prorogue the session. But prorogue, end the session. Unlike adjournment, prorogation terminates the session of the house. Terminates session. Now we are going to have fresh session. When I say quorum, I told you minimum number of members which are required for continuing the house proceedings, that is 1/10. If there is no quorum, it means what is going to happen? Presiding officer can actually adjourn the session or suspend that particular session. That you have to come again with a due strength. When it comes to voting in the house, all the matters at any sitting of the either house, they are done by simple majority, means majority of members who are present and voting. Is specifically in some instances we have other, you can say other majorities which we call say special majority, effective majority. Only a few matters which specifically mentioned in constitution, removal of the speaker of the assembly, chairman removal and so on, special majority, you can say effective majority in this case, not ordinary majority is used. The presiding officer, speaker of the house or chairman in case does not vote in first instance, you all know that. Whoever is going to preside the house, that's a rule. That person cannot vote in first instance. First voting should happen, matter should be decided. If there is a case of tie, then only presiding officer can vote. We call it casting vote, right? Rights of ministers and advocate general. Both have this common function. Whichever house member you are, in case of minister and advocate general, it means you can say topmost legal officer of state government, they can actually present in any of the house. They can take part. They can speak also if they are asked to speak, but they cannot vote. Means minister can vote only in that house in which minister is member, and advocate general obviously cannot vote. So minister and advocate general of the state have right to speak and take part in the proceedings of the house. Minister can participate in the proceedings of the house which he is not a member. Consider a minister who is not a member of either house. It means that minister can continue in such position for 6 months. Before that, that minister has to be part of any house. Not a member of either house can participate in the proceedings of both the houses. Same case, right? So please remember, either house and speak, but vote only where you are member. Clear? Legislative procedure of state legislature means how laws are made in state legislature. Consider ordinary bill. So ordinary bill can originate in either house, whether legislative assembly or legislative council. Such a bill can be introduced either by a minister or other member. Please remember, this particular provision is applicable only in case of ordinary bill, not in case of money bill. Because in case of money bill, it can only be introduced by a minister. Why? Because money bill talks about matters related to expenditure from Consulate Fund of India, or in case of state, Consulate Fund of State, right? Increasing taxes, decreasing taxes, such kind of functions are there. Although in case of taxes, a lot of powers by state has been shifted to GST Council now. But the point is, related to expenditure revenue, who is going to take such reasons? Government, right? And that is why minister actually introduced this money bill. Okay, that is why it is called public bill. Okay, government bill you can say. After the bill is passed by originating house, it is transmitted to second house. A bill is deemed to have been passed by the state legislature only when both the houses have agreed to or with or without amendments. Same case. In case of unicameral legislature, you just need to introduce this bill in legislative assembly. When it is passed, it is presented before governor and governor signs, it becomes an act, right? So it means bill presented in state legislative assembly, then this, when it is passed from here, state legislative council, when it is passed from here before governor, governor signs and it becomes an act. If state legislative council is not there, then this bill is going to be presented in state legislative assembly and directly it is going to be presented before governors. Okay. Now bill in second house. Consider a bill is cleared by Legislative Assembly and presented before Legislative Council. Now there's an important aspect, question can be asked. Sometimes UPSC actually try to compare within a statement this particular part of State Legislative Council with Rajya Sabha. And it is going to be quite simple for you. We are going to discuss each and every provision. When a bill is passed by the Legislative Assembly and transmitted to the Legislative Council, the letter has four alternatives. One, may pass the bill as it is, okay, without any amendment. May pass the bill with amendment, saying that we want these changes. In this case, this bill needs to be presented again, return to Legislative Assembly, okay. May reject the bill altogether, that we are not agreeing with that, or may not do anything. So these are the four alternatives with Legislative Council. But what impact it is going to have on the bill? If the Legislative Assembly rejects the amendments suggested by the Council, for example, this second point was used by Legislative Council, that we want these changes. Now Legislative Assembly is saying, oh, you are saying these changes. Okay, we are accepting it. It means if we are accepting, now it is going to be presented before Governor and Governor signs and it becomes an act. But it may be possible that Legislative Assembly says we are not accepting, we are rejecting the amendment suggested by you. Council does not take any action for 3 months. Now they are presented this bill again to the Council that we are rejecting, and now Council is, say, in first instance, Council actually took this bill on hold for 3 months. Okay, in first instance, Council can actually hold the bill only for 3 months. Okay, and then this bill is presented back to the Legislative Assembly. Okay, so now you should remember, in first instance, Legislative Council can hold the bill only for 3 months, and in the second instance, with amendments or without amendments, when Legislative Assembly is giving back the bill to the Legislative Council, this time Legislative Council can actually hold the bill just for 1 month. It means maximum delay period can be 4 months, not more than that. I hope you are able to understand. Legislative Council has less status when it comes to legislative power in comparison to Rajya Sabha. In case of ordinary bills, we discussed, if there is a case of deadlock, it means legislative, for example, Rajya Sabha is not agreeing with the amendments proposed by Lok Sabha, or Lok Sabha means there's no consensus between two houses. In that case, joint sitting can happen. But in case of state legislature, no case of joint sitting is mentioned. Please remember it, there was question asked on this. So in case of state legislature, Legislative Assembly has more say. The Assembly may pass the bill again and transmit the same to the Council. If the Council rejects the bill again or pass the bill with amendment not acceptable to the Assembly, does not pass the bill within 1 month, as I told you, then the bill is deemed to have been passed by both the houses in the form which it was passed by the Assembly for the second time. So it simply says, whatever Legislative Council can do is to stall the bill for 4 months at max. That's it. Legislative Assembly has more say in ordinary bill as well as money bill. Let's attempt this question so that it can settle in your mind a better. The Constitution does not provide for the mechanism of joint sitting of both the houses in state to resolve the disagreement between the two houses over a bill. You have to say the statement is correct or not. Okay, the statement is correct. I've just told you this. Council can detain or delay the bill for a period of 4 months. 3 months first instance, 1 month second instance. I've just told you it is correct. The Council has been given lesser significance, position, authority than Rajya Sabha at the center. This is what we discussed. Correct? It means answer is all of the above. Right? I hope it is clear now. Now assent to the Governor. Consider the bill is passed, okay, from Legislative Assembly and Legislative Council. Now before Governor can give assent to the bill, then it can become an act. Governor may withhold the bill, then it will not become an act. May return the bill for reconsideration, but this return can happen once, and when it is sent back to the Governor that we are not agreeing with that or we have accepted some of your suggestions, then Governor must accept it. Same is the case with President. May reserve the bill for reconsideration of, you can say, President. So it means assent, withhold, return and reserve. This part we discussed when we were comparing the powers between President and Governor also, right? If governor gives assent to the bill becomes an act. Withhold, the bill ends. Return the bill with or without amendment. Presented to the governor again, governor must give his assent. Means for once this can be returned. Thus the governor enjoys suspensive veto. The position is same as central level also. Same provision is with president. Now in case of money bill can be introduced only in legislative assembly. Same is the case at union legislature. It can be only introduced in Lok Sabha. I hope you remember. Bill is transmitted to the legislative council for its consideration. It is passed from legislative assembly, sent to the legislative council. Now legislative council cannot reject or amend money bill, can only make recommendations and must return the bill to the legislative assembly within 14 days if they have some suggestions. The legislative council does not return to the legislative assembly within 14 days. If such thing happen, then the bill is deemed to have been passed. It means in case of money bill, a maximum period for which legislative council can hold this bill is 14 days only. In case of ordinary bill, it was 3 months plus 1 means 4 months. Finally, when a money bill is presented to the governor, he may either give his assent, withhold his assent, or reserve. The bill is for presidential assent cannot return the bill for reconsideration of the state legislature. I told you in this comparison also that money bill cannot be returned because it's a wastage of time, right? And money bill means it is possible that government is raising money bill because there is some essential, means some urgent matter is there. It may be possible. Expenditure of government is dependent on it, right? Normally, the governor gives assent to a money bill as it is introduced in state legislature because it is introduced with prior permission of governor. Same is case of state as in case of center, right? In center, money bill can be introduced in Lok Sabha only on the prior recommendation of president. Now, attempt this question. Money bill can be introduced by any member or minister in legislative assembly. Do you think it is true? No, it is false. How can any member introduce? Right? It's a government bill. Ministers introduce. The legislative council has restricted powers with regard to money bill, right? Money bill is as it is introduced in the state legislature with his prior permission of the governor, right? President can return the bill to the state legislature for reconsideration, but governor can't. Means it is saying that president can return what? Money bill. No, it is not possible. As I told you, when a money bill is reserved for the consideration of the president may either give his assent to the bill or withhold his assent to the bill, but cannot return. As I told you, it's a wastage of time. That should not happen in case of money bill. Now, position of legislative council. So, there are two cases here. The areas where legislative council is having equal say as legislative assembly, and then second case is unequal. Okay. One question can be made from here. Okay. Introduction and passage of the ordinary bill. So in case of ordinary bill, it can be introduced in either house, means legislative assembly or legislative council. However, in case of disagreement between two houses, the will of the assembly prevails over the council. Will of the assembly prevails. As I told you, there is no case of joint sitting there. Approval of ordinances issued by governor means once governor issues ordinance under Article 213, when house is reconstituted, then it must be passed from both the houses. Selection of ministers including chief minister means if someone has to be appointed as minister, then that person can be a member of either house. Like in case of Yogi Adityanath, he was member of legislative council. Consideration of reports of the constitutional bodies like State Finance Commission, State Public Service Commission, Comptroller Auditor General of India, yes, CAG's report with respect to state, right? So it can be considered by the both houses. Enlargement of jurisdiction of State Public Service Commission, in this case also, they have both houses have same say. Now my suggestion to you is, please remember these 2 points, because earlier 3 points were quite obvious. These are the points which generally students actually forget. Okay. Unequal. In case of money bill, it can only be introduced in legislative assembly, not legislative council. Final power to decide whether a particular bill is money bill or not, it is with Speaker of Legislative Assembly only. The final power of passing an ordinary bill lies with the assembly. Means legislative council can hold this money bill only for 14 days. Council can only discuss the budget but cannot vote on the demand for grants. Cannot vote, only discuss. Please remember. Council cannot remove the Council of Minister. Why? No confidence motion can only be passed in Legislative Assembly. Same in case of Lok Sabha, right? And when an ordinary bill which is originated in Council was sent to the Assembly, it is rejected by the Assembly, the bill ends and becomes dead. Remember it. But in case of Rajya Sabha, this doesn't happen. Why? Because there's a case of joint sitting there, right? If there's a deadlock. But if Legislative Council proposes a bill and Legislative Assembly rejects it, then it is dead. It ends. Please remember it. The Council does not participate in the election of the President because in case of election of President, only elected MLAs vote. I hope you remember. Now, privileges of state legislature. Compare with what we discussed in Parliament. It has right to publish its report, debate, proceedings, and also the right to prohibit others from publishing the same. Prohibit others from publishing the same. Although after Supreme Court judgment, any truth can be actually presented, or you can say published by the media houses. Okay, truth, but it should be truth. It should not be you can say their opinion which demeans the house. Otherwise, that is going to be considered you can say against privilege of the house. It can exclude strangers from attending the proceedings. It can make rules to regulate own procedures. It can punish members as well as outsiders for breach of privilege. Same. It has right to receive immediate information of the arrest, detention, conviction, imprisonment or release of member. That is collective privilege. Can institute inquiries, order to attendance, witness and send of relevant papers and record if matter is under consideration there. Court are prohibited to inquire the proceedings of the House or its committees. This protection has been given to the House. No person, either a member or outsider, can be arrested. No legal process, civil, criminal, can be served within the premises of the House, okay, without the permission of presiding officer. Individual privilege, same. The MLA or MLCs, they cannot be arrested 14 days before, 14 days after and during the session. The privilege can only be available in case of civil, not in criminal cases or preventive detention cases. Their question can be asked. So this protection is available only in civil cases. For example, case related to tax, family or land dispute, etc. If you have murdered someone and you are thinking, no, for at least 40 days before, 40 days and in between session, you are not going to be arrested, then you are mistaken, my friend, if you are MLA. They have freedom of speech in the state legislature. No member is liable to proceedings in any court, whatever they say within the House. They are exempted from any jury service. So jury services itself ended. Now it is not used, right? There can be a mains question from here. We say that freedom of speech to the in the state legislature. Do you think there's truly a freedom of speech? Because if an MLA of a party speaks her mind and his opinion is against the opinion of majority of its party members, then this can be a basis of disqualifying this particular member. So now this member is becoming a sheep of the herd. This member is not having independent voice. So some people say this is actually against freedom of speech and expression. So how anti-defection law is curbing freedom of speech and expression of these members? How these members are reduced to party members, not true representative of their people. So this can be a question here. Now, Council of Minister does not include whom? Parliamentary secretaries, because all three categories are part of COM. I discussed with you in video number 1. Video number 1 of state legislature. Using which of the following can terminate a sitting of the state legislature for an indefinite period? Adjournment sine die. Please remember, we are using word sitting, not session. That is why adjournment sine die. This is a factual question. Madhya Pradesh 7th Amendment Act, part 1 video of state legislature, and within the start I discuss these facts. Article in the Constitution provides for dissolution of a state assembly by the President. Article 56, President Rule. Suppose the Legislative Assembly dissolves. Now you have to answer this. And suppose a bill has already been passed by Legislative Assembly and also Legislative Council, but is returned for reconsideration by the Governor. Means the bill has already touched the Honorable Governor. President at time dissolution. Then what will happen to the bill? Tell me, the bill will lapse or not? The bill will not lapse because that bill has already touched the stage of Governor. So I hope now this topic is clearer to you, right? If you have any doubt, you can shoot me a message on my personal Insta, shashank.powerbeam. This PDF is going to be available in this Telegram group, Shashank Tyagi for you. See you in the next video. Till then, keep learning, keep growing.